Welcome back. This is the final session of the conference, and it's going to be a really exciting one, we hope. It's our roundtable on the future of legal methods. And one of the kind of purposes behind this is really to practice what we've been preaching all along, both in the conference and in the journal and in the Cubicle project, which is the parent of all of this. We've brought together an absolutely fabulous panel of commentators here today. I'm just going to introduce everyone, but really to highlight the fact that they're from across the legal landscape. So really representing a whole different set of perspectives on the rule of law, on legal tech, on its proper role in the world of law. So we'll begin with a keynote from Professor Scott Veitch. Professor Scott Veitch writes and teaches in the areas of legal, social, and political theory. He was educated in my native Scotland. He's worked in universities in Australia and the United Kingdom and was formerly a professor of jurisprudence at the University of Glasgow, which I think is a role that you share with Adam Smith. Is that right? Yeah. Professor Veitch's area of research is jurisprudence, broadly defined, and his work draws on historical, philosophical, and sociological insights into law and legal institutions. Then we have Sophia Adams-Bhatti. Sophia is a public policy expert with over 20 years' experience across law, financial services, competition, consumer affairs, healthcare, and immigration and asylum. She's a specialist in AI ethics, human rights and regulation. She measures on the intersection of law, policy, and technology. She started her career at the UN and is currently the global head of policy, purpose, and impact at Simmons & Simmons LLP, a global law firm headquartered in the City of London. Previously, and very relevantly for today, she was the Director of Policy and Regulation at the Law Society of England and Wales, where she led a large team focused on law reform programmes, and as part of which she spearheaded groundbreaking investigation of the use of AI in criminal justice. Willy van Puymbroek, sorry if I'm murdering your name there, he obtained a PhD in physics from the University of Antwerp in 1981. He joined the European Commission in 1988 and worked as a software engineer in the telecommunications industry before that. At the European Commission, he held various different positions, mainly working in DG Connect. And in 2018, he moved to DG Digit and took on responsibility for IT solutions for legislation, policy, and HR. And crucially for today, in 2020, he became the active senior in the Commission working on LAOS, which is the system used to draft legislation for the European Union. Anna Drozd is a senior legal advisor with the Council of Bars and Law Societies of Europe, the CCBE, which represents bars and law societies of 46 countries. She works with the CCBE experts on issues relating to digitalization of justice, new technologies, including AI, and their use in legal practice and the justice system, professional ethics and obligations, including professional secrecy, legal professional privilege, and the future of the legal profession, very relevant for today. Prior to joining the CCBE, she worked as a policy advisor with the UK Law Societies in Brussels, focusing on data protection, technology, professional regulation, ethics, and trade policy. Martijn Loth is an attorney with the international law firm Taylor Wessing. He's based in Amsterdam, and his practice is focused on outsourcing deals, IT disputes, advising on new technologies, and regulatory compliance with data protection and e-commerce. In addition to his legal background, Martijn has a technical background in Linux system administration and software engineering. Cari Hyde-Vaamonde is an experienced lawyer and court advocate with an interest in the potential for code and AI to reform how law and justice function. Her focus on research in this field recently culminated in a UKRI 4-year award to research the impacts of AI in justice settings at King's London, where she's also a visiting lecturer. She's also co-convener of the Innovations in Judging Collaborative Research Network for the Law and Society Association. Denis Merigoux, we heard from yesterday. He's a starting researcher at INRIA in Paris in the Prosecco team, specializing in the study and design of programming languages and formal verification. His research domain is at the intersection of computer science and law, and his goal is to improve how the law turned into computer code is applied automatically by information systems used by government agencies and companies. More particularly, he focuses on systems that levy taxes or distribute social benefits. And after co-designing the Catalan domain-specific language with lawyers for use in calculating taxation and benefits, he's collaborated with the French tax authority on a tentative rewriting of the income tax computation algorithm in Catalan, the language that he co-designed. And lastly, but not least, we've got Professor Lyria Bennett-Moses, who we also heard from yesterday. She is the director of the Allens Hub for Technology, Law and Innovation, and is a professor and associate dean of research in the Faculty of Law and Justice at the University of New South Wales at Sydney. She's also co-lead of the Law and Policy theme in the Cybersecurity Cooperative Research Centre and faculty lead of Law and Justice in the UNSW Institute for Cybersecurity. Lyria's research explores issues around the relationship between technology and law, including the types of legal issues that arise as technology changes, how these issues are addressed in Australia and other jurisdictions, and the problems of treating technology as an object of regulation. Now, the format of the keynote will begin with, the roundtable will begin with a keynote from Professor Veitch. Then we'll ask each panel member to give one point that they thought was particularly interesting or salient from Professor Veitch's keynote. From their perspective, we're going to try and, we're going to ask you to limit it to 1 point. So you really have to focus in on the kernel of what you think is most interesting or relevant for you. Then we'll take some questions from the audience. We'll have a short coffee break, so don't worry, this is not just one long session. Then we'll have some presentations from the panelists, again, cross-disciplinary presentations, 10 minutes each to talk about issues of legal tech, rule of law, from your professional and your experience, and the perspective that you have, given your perspective, given your experience in the professional world. We'll have some final comments from the panelists, commenting on one another. Again, cross-disciplinary dialogue, questions from the audience, and then we'll wrap things up. So without further ado, I will pass over to Professor Veitch for the keynote. Thank you.
Thanks very much, for being here, and thanks in particular to the Cubicle members. It seems to me that they're to be congratulated for the immensely sophisticated attention that they're giving to the issues that they've identified in this project. And these issues are certainly, it seems to me, at the cutting edge of some of the most pressing concerns of our time. I think, like everyone else, I've learned an awful lot, not just substantively this morning and yesterday, but from the form and the style in which these intellectual engagements have been conducted. This is remarkably refreshing. And I think, like everyone else, I'm sure I've had my thoughts provoked in a number of diverse ways. What more could one want? In particular, I think the proximity, and we see this on the panel, the proximity, between practical and theoretical concerns that have been central to the methods and to their discoveries and their writings means that these studies will undoubtedly inform future developments in the era of computational law. It's some measure of this, I think, that this stellar panel here today come from such a wide range of expertise in legal and technological backgrounds. I do hope they will find that 1 point of interest in what I have to say. Lawrence upped the stakes a wee bit by saying that I also, like Adam Smith, gave lectures in jurisprudence at the University of Glasgow. So there's a wee bit pressure there. But I was, in fact, thinking that one of the things that I take from Adam Smith's lectures in jurisprudence, which were never, in fact, published, but they were published from student notes, some as late as the 20th century, when they were discovered, show an immense awareness for Smith of the importance of history, ethics. He was a professor of moral philosophy, in fact, in Glasgow. Economics, although it wasn't, he didn't do economics, ironically enough, but also politics, technology, agriculture. The whole range of these factors were absolutely crucial to the way in which he understood and gave his lectures in jurisprudence. And I think maybe in the water, I've imbibed some of this as well, because that's my background. My background is in legal philosophy, but very broadly construed. So I draw on all these different resources to try and understand what's going on. That's it. And what is going on? Well, it seems to me that one key observation is that the field of normativity is being reconfigured today. There are new alignments of agency and normativity that are coming into being. And it's these that call for our urgent attention. And I think the Cubicle project and those participating here in it are at the forefront of addressing these concerns. So, what I want to do then in the presentation today is address two themes from the title of the conference and the project itself. One is the future of legal method, and the other is the question of being human in the age of computational law. Addressing these and the many other questions that are really helpfully detailed in the research studies that the project is producing, addressing these are going to be crucial to any engagement with computational law. And particularly, as we've seen in a few presentations, the enticements of computational law as it grows more attractive and irresistible, at least to some. So, to explore these, I want to make 4 points. The first addresses the issue of the future that's in the title, but I want to do it in a rather different way from those in which they've been looked at so far. The second point follows on from this and considers indirectly, you might say, criticisms of the opaque nature of code-driven law. With a friendly nod to Frank Pasquale, I don't know if he's online or not, he's still asleep, and his incredibly important book, The Black Box Society, I want to suggest that there are important senses in which there is a black box quality to law itself. What this is and what it means going forward will, I hope, benefit from some brief exploration. The third thing I want to do, I do under the heading of constituencies. I want to open out our thinking in this field to engage the range of actors involved, only some of which, it seems to me, register in either text-driven law or code-driven law. It seems to me that a key aspect of this realignment of the normative field in the digital era involves questions of who is speaking and who's being spoken about, whose interests are being represented and whose are not. Some of these are long-standing constituencies, professional, legal, technical, academic, professional, bar, all these kinds of bodies. But we also need to open out our inquiry into whether new forms of agency have been sufficiently taken into account in thinking about text-driven laws affordances. The question arises, in other words, whether text-driven law is capable of addressing the kinds of agencies and actors that are core to contemporary developments in the computational era. The final thing that I want to do is to say something about values and offer a couple of different readings about how these might play out at the interface of text-driven and code-driven. So that's what I'm setting out to do. So let me turn to the first point again, which is this. To understand the future of legal method, we need to understand its past too. I have a sense that there's a risk of some kind of false memory syndrome in accounts of text-driven law that we would do well to avoid replicating going forward. Pointing this out matters not only because of the importance of the accuracy of the historical record, but because as we proceed, as we go forward, it might impact on what we can expect both of the rule of law in text-driven law and what we might expect of code and data-driven law. So getting an accurate account of the past will aid enormously in engaging with the problems and new domains and styles of computational law. My provocation here is that while the affordances of text-driven law are capable of protecting legal subjects, there are less edifying aspects to the rule of law too. The rule of law, and indeed the rule of law in a democracy, is compatible with great inequalities and indeed injustices. This isn't a bug in the system, it's a feature. The rule of law is capable of doing both, protecting some and not protecting others, not only in the past, but in the present as well. Indeed, one of the ways of operating the rule of law historically was to assign some members of society as equal citizens while treating others, whether it's slaves, women, people of color, as bound to non-negotiable, non-challengeable, code-like positions. The two went hand in hand. So there might be more to laws' affordances, in other words, than meets the eye. And this is true not simply with respect to the substance of any particular laws, but to the forms of action made possible and made legitimate under the rule of law. Mireille said yesterday that humans are capable of bias, and that's why we have law. But we ought also to be alive to the reality that we have biases because the law itself organizes and sustains them. We shouldn't shy away from this by saying that there have been exceptions or misapplications or bugs, or we could do better, but we need to engage with it head on. Why? Because otherwise, biases will be baked into the computational law and legitimated by text-driven laws oversight. So it matters to draw attention to this because it might reconfigure our sense of what we demand of and what the possibilities are at the interface of text-driven law and code-driven law. The second point I want to raise follows directly on from this. In thinking about the values that text-driven law can serve and which are worth protecting, this is not a criticism that I'm making in general. I want to be absolutely clear, and I know this from personal experiences, that where there are places where the rule of law has broken down, you don't want to be there, right? Because the kinds of concerns, the arbitrary power, et cetera, the violence, the naked violence is horrific, or potentially horrific, and always potentially horrific. So I don't want to negate the values of the rule of law. My first point was to say that the rule of law is both capable of protecting citizens, but in its history and to some extent in its present, but the question is about its future, whether it's also going to be operating to legitimize the kinds of injustices and inequalities that it has done historically. However, serving these values, we ought to be aware that there are therefore important limits to text-driven law too. Text-driven law has blind spots that might best be understood, as I've suggested, by seeing that there are certain black box qualities to law that we might benefit from thinking about more closely. As we go on and try to grapple with the relationship between law and digital technologies, we need to be attuned to what text-driven law can and cannot do, what is visible to it and what is not, and how its inbuilt assumptions, text-driven law's hidden affordances, condition, how these condition its possibilities and its limits. Okay, so what do I mean by this idea that there's black box law? Well, it's not this. Most people, most citizens don't know anything about the law. They don't know most of the laws. They don't know how it works, whatnot. That's true. To many people, the law is a black box in that sense. Entire ignorance. In fact, to many lawyers, it's something like that. Most lawyers don't know most of the law. What they do know is enough, and they know how to find out. And when they find it out, they know how to work with it, how to argue with it, and so on. So it's not that sense. It's not what's largely visible or invisible that I want to talk about. It's what is either not largely visible, both to citizens and lawyers, or, and this is the deeper point, what is constitutively not possible to see from a legal point of view. All right. So an example of the first kind, it would be that there are certain things that are, so to say, baked in, that we assume, baked in the assumptions into the law that we tend, even as lawyers, even as well-informed citizens, not to think about. Right? These are absolutely crucial to the operation of our legal system. Here's an example, an employment contract. So they operate in a way, something like the employment contract as a gateway into all kinds of conditions that are not visible from looking at the contract. Contract is a kind of gateway drug. It gets you into the really hard stuff. Yeah. What kinds of things? Well, you're put at the mercy of managers and the kinds of discipline and control that varies regularly without much or any legal oversight whatsoever. Academics' tenure and promotion chances based on really dodgy statistics like metrics, citation metrics, journal impact factors, all that kind of stuff has become part of, at least in many countries, the norm of what it means to have an academic employment contract. A second level to that, slightly deeper than that, there is the very assumption that a core part of who you or we are, your ability to do things and create things, can be commodified and sold to someone else for their benefit. The labor contract assumes this, but it is, Karl Polanyi famously pointed this out, it's purely a fiction. Along with land and money, said Polanyi, that this aspect of being a human is a commodity. Nonetheless, it's the hidden working assumption, not only of a market society, but crucially one that legal systems are themselves obligated to establish and protect. This law of value is something that legal systems, when you see a transition from, let's say, a formerly socialist country into a liberal democracy, what's the one thing that they need to protect? Labor and contract of employment, property, and so on. These things are obligatory in the kinds of documents that are enacted in these places. There's another observation, or this observation maybe, leads to a more general one that's often hidden to lawyers themselves as they argue for the value of law's affordances. There's an example of this even in one of the most sophisticated accounts of the co-constitutive nature of modern democracy, human rights, and the rule of law, namely Jürgen Habermas. Somewhere in his huge body of work, he says this, I'm just going to quote, subjects who want to regulate their living together by means of positive law are no longer free to choose the medium in which they can realize their autonomy. They participate in the production of law only as legal subjects. It is no longer in their power to determine which language they will use in this endeavor. It seems to me to have something of the black box quality that we might want to hold on to. And it's this lack of choice about language, medium, that is not necessarily conducive to certain kinds of community that can be seen by looking at one, and this is the final deeper level, of the black box account of law. And to do this, I want to use an example from Australia and the Australian High Court. As many of you will know, in 1992, the Australian High Court in the Mabo decision was asked to reconsider the nature and consequences of the acquisition of the landmass of Australia by the British Crown in the 1770s, end of the 18th century. The court said that while it could consider what followed from this acquisition, because that was a sovereign act, the court could not consider its validity. Not just that it wouldn't consider it, that it couldn't do so. So the highest court in the land was limited as to what it could do in declaring the law. Why? Because were it to address itself to the acquisition of sovereignty and to find out that it was unlawful, then the court itself would have no jurisdiction over that question. It's this blind spot that allows the court, allows the law to see, but at the same time bars it from seeing other things. And not only can the court not see certain things, it can't see that it can't see them. Right? This is the systems theory point. That's as technical as I'm going to get, hopefully. It not only can't see it, but it can't see that it can't see. And that's the condition of it seeing. Right? A bit complicated, but I think you can follow. So in the Australian setting, given the imperialist, racist nature of the acquisition and what followed from it, this colonial act is baked into the legal system, which in turn simply cannot address it. So what appears from one perspective as a straightforward theft of land that is not theirs and the genocide of indigenous people is, from the legal point of view, an act of sovereignty that founds the common law and the legislative jurisdiction of the modern Australian state. This isn't novel to Australia. Although the specific conditions might vary, this blind spot is common to all states in modern law. It's arguably, and I'm just going to throw this out there, it's arguably one of the key problems about addressing climate change as well. There is this blind spot, this statist blind spot that is allowing all kinds of horrific effects to occur and to continue to occur legitimately as we go forward. Anyway, what this point also symbolizes is that no matter how much you try to correct for bias in code-driven law or in text-driven law, when the programs are built upon foundations of bias that are simply assumed or unaddressable, no amount of tinkering by the developers or the lawyers will be able to address the foundation of injustice on which everything else relies. Okay, third, I want to, as I said, raise concerns about what we might call constituency issues. This is something that's come up a few times in the presentations at this conference and is directly of interest to the panelists here and the different constituencies and way that they've been thinking about their influence or what they might do in terms of going forward in this computational era. So it matters who or what we're talking about when we think about agency and audience, identities and interests. Importantly, there are numerous constituencies that go beyond the relationship of citizens and the state, citizens and the demos, we might even say. One of the challenges thrown up by new technologies is that there is a splintering of identities under digitalization and datafication processes. A number of papers have addressed this point. This means that as well as questions about the proper relationship between citizens and states under the rule of law, the reality is that we have a pluralized field of agency. or perhaps better, fields of pluralized agency. Across this field, there are many more actors and styles of action than might be visible in text-driven law and its category. Consider two examples. First, arguably, much of what being human involves is, in the computational age, missed out. It's not legible if it can't be digitalized. Common point many people have made. In particular, however, I would want to stress that many forms of collective don't register, except a statistically produced aggregate. Many collectives didn't register in text-driven law either. This was a point that was made by Neil McCormick somewhere when he said, it's odd that we get concerned when we think about legal fictions, that there is no such thing as a corporation, but we invent it and we make these things up. He said, it's actually more interesting that there are a number of groupings in society that don't register in law whatsoever, but are much more real than the things that we make up. So anyway, so it's a problem for code-driven law. It also was a question for text-driven law too. If we're going to respond to the future challenges of code-driven law, then we need to understand, as the Cubicle project is doing, how legal institutions and the rule of law have come into being through challenges of certain forms of collectivity historically. And the question now is what shape these need to take in the computational age. What I mean by this is that many of the developments in democracy and the rule of law were made in the face of often violent opposition of those who sought to defend the status quo. The privilege of men, property, and wealth, of entrenched racialized domination, often had to be challenged with great force and determination and sacrifice in order that they yield. This required, as we all know, movements of feminists, socialists, anti-fascists, often in coalition, often not. Collectivities and solidarities were drawn on and developed that didn't necessarily register in the law, and indeed, they often had to fight against entrenched legal privilege in order to succeed in the progress of dignity and equality. At Adam Smith's time, it might have been combination of workers and the ways in which they were suppressed well into the 19th century. So the question then, what new forms of solidarity are required in the computational age if we are to be human and humane within it? As everyone knows, forms of entrenched power haven't disappeared in the digital age. It's entirely clear to see that inequalities are being exacerbated. Tech companies and others are central to this. It's important to keep in mind, though, that none of this is illegal. When we call for legal regulation of AI, we tend to forget that the law, the rule of law, and democracy has already been there. They've provided the affordances for these power differentials to coagulate. Democratic law isn't neutral here. It protects equally rich and poor, powerful, and sometimes the vulnerable. Such entrenched positions are sustained not only through private law doctrine, property, contract, trust law, but through constitutional entrenchments too. So what possibilities for disturbing these current arrangements are available through legal protection, when legal protections are themselves arguably part of the problem? What kind of new collectivities, new solidarities are required that haven't yet been formed or registered or made legible or even imagined that might be necessary to protect us being human? Democracy and the rule of law historically are cultural achievements, not just procedural ones. And in that sense, we can't think about how best to achieve their goods without strongly engaging with the cultural conditions in which we live and which are forming around us. There's a second kind of problem that needs more attention here. It's this. What kind of power is code-driven law exercised? That it needs to be constrained. What kind of power is algorithmic power? The last paper before the break was beginning to talk about this. It's not clear that it's arbitrary just because it self-executes. The analogy might not be with the king, the sovereign who makes and applies the laws, not least because code-driven law may be perfectly regular and rule-bound, and it may be neither capricious nor even unaccountable. If the power in code is less like the old sovereign's power and more like nudge, choice architecture, forms of disciplinary power that circulate through agencies, agents, institutions, and so on, rather than being held and identifiable in one sovereign place, then we need to think differently about how we constrain it. There's no point storming the palace or even the parliament if these are no longer the places or styles in which power resides or operates. It's not just a matter of location, but of form, of different styles or formations of power that the computational age inaugurates. And with respect to an important key concept in the project, with respect to counterpower or counterplay, we have to ask, is text-driven law up to the task? Aren't new forms of counterpower needed, including, we ought to be open to this, particularly as lawyers, non-legality counterpower? What, for example, are the kinds, again, of solidarity that are appropriate to addressing these new forms of power if it is to be constrained as it operates both below and above the level of the state? This, it seems to me, has important implications for thinking about the interface of text-driven and code-driven law. But if the rule of law is, as Martin Krieger describes it, as a colleague, as he describes it, if the rule of law is about tempering power, we need to be aware that, like tempered steel, power can be augmented too by subjecting it to the rule of law. An old-style rule of sovereign might be stronger, albeit in different ways, from an arbitrary but constantly vulnerable sovereign. Rousseau, you might recall, said this: the strongest are never strong enough, always to be the master, unless they transform strength into right and obedience into duty. So the question, are the protections afforded by text-driven law appropriate to the power exercised under code-driven? If not, then we might need to rethink the protections and affordances at the interface between the two. It seems to me that all this involves paying attention to the potential for certain transformations of basic ideas and concepts and values of modern law: agency, responsibility, causation, for example. Perhaps the old categories of the rule of law are inadequate to this new task. Perhaps new collectives are where the action has to be. Otherwise, the danger, as it might currently be unfolding, is of a complicity between a democratic rule of law and new forms of power in which the latter are becoming steadily immune from the former's reach, not least because they are authorized by it. We might think about this in the memorable terms that Jonathan Schell used in his powerful book, The Fate of the Earth. He was writing about the threat of nuclear weapons. This was in the 1980s. Those of you who were there then will remember just how present these were in our minds. He said this: we try to make do with a Newtonian politics in an Einsteinian world. This is the source of our immediate peril. We try to make do with a Newtonian politics in an Einsteinian world. I think this captures some of the challenge that the computational era is presenting to us. Just an aside, we've got, I don't know how long I've got left. Okay. like probably most of us, we are content to say us, we. But arguably, this easy usage covers over a lot. The story of the Lone Ranger and Tonto, his sidekick, comes to mind. Some of you may have heard of this, the Native American Tonto. They're riding through the desert one day and they're surrounded by a bunch of apparently hostile native warriors. And the Lone Ranger turns to Tonto and says, "Tonto, what are we going to do?" And Tonto replies, "What do you mean, we, white man?" When we talk about what we are going to do, what do we mean? We. This might be added to the list of Mireille's questions that we always ought to keep in mind. Okay, the final issue then, fourth issue, I'd like to address concerns values. One of the key insights about text-driven law, and this is central to the project, is that it can contain conflicting and even incommensurable values. Lawyers and law students grow up knowing this and how to deal with these clashes and face them daily. The conflict, say, between private life and freedom of the press. Does dignity trump the right of dwarves to work, getting thrown around in their employment for other people's pleasure? Is self-defense a good ground for killing innocent people? And so on. One question here is, can code-driven normativity contain contestability? This is a question that Lawrence and others address in their work, but it's a problem that is built into text-driven law, which seems currently unaddressable rather, an unaddressable problem for code. Maybe this is a good thing. It's a problem not to be solved. Isaiah Berlin, the famous liberal, pointed out, incommensurability of values makes us who we are. They are the thing that is worth holding on to. The crooked timber of humanity, he quotes Kant, out of which no straight thing ought to be made. Or, in Philip Roth's term, there's the human stain for which we simply cannot and should not find a stain remover. Mireille points out the fact that human well-being is incomputable, however, doesn't mean that it's not being computed with. And I think this is at the forefront, or should be at the forefront, of this interface about what computational law can bring and what we should avoid it for. There's a marked tendency, as we saw in Saish's paper yesterday, and it's certainly pushed by the PR frontmen of tech companies to sell the advantages of computability. And the logic is usually something like this. Here's the solution. What's your problem? Right? In this sense, it's not unfair to suggest, as Kyle McGee did in a very engaging review of Mireille's book, that techno-regulation is the enforcement wing of law and economics. So some account of the values at stake here is necessary. Some are directly engaged, transparency, accountability, and so on. Some are more byproducts achieved indirectly, social, or professional, or expert trust. Some can only be addressed at scale, legitimacy, for example. But what these are and how we might shape up to them is a key problem, and I think a number of the panelists will take these up. So let me end then with a thought experiment in which, ironically, something like ChatGPT might, we imagine, help. It's something suggested by Orly Lobel in the epilogue to her book, The Equality Machine, that came out last year, I think. Imagine, she says, an algorithm that is taught fairness theories about equality and distributive justice. John Rawls, she continues, gives us a paradigmatic formula for thinking about justice in liberal societies. She says the possibilities of encoding such principles into the machine with deep learning capabilities are endless. Indeed, they are. They might also be beginningless for some obvious reasons, not to do with the programming, but to do with what we're currently prepared to accept as being part of our rule of law democracy that already exhibits equality and fairness. Let me give you one example. This is from the United Kingdom, but I'm sure it has other manifestations. Imagine that you program in John Rawls and you say, how does the UK work out? Think of the amount of manipulation the program would have to do to design the British system, right? Okay, so what do you want? We want a head of state. Sure, everyone has a head of state. Yeah, but we want this one to be unelected and hereditary. Okay. We want this person, the Queen, now the King, to be an utter free rider who has a huge amount of wealth but doesn't give any away unless they want to. Okay. They can choose to pay tax. Okay, well, we could do that, right? Okay. That's one thing, head of state. What about your prime minister? Well, we want them mostly to have gone to the same school. All right? Eton. Okay. We can sort that out. Does that meet equal opportunities, the Rawlsian principle? Yes, it does. I mean, it's not excluding other people from becoming prime minister. It just so happened. Okay. We can go along with that. We want most of them in important positions to be men. Okay, right. Can we do that? Well, think of the program is whirring around at this point, thinking, okay, we can still do this under democracy and the rule of law. Okay, we want to apply Anatole France's principle that both the rich and the poor are free to sleep under the bridges. No problem, right? You just have to walk through London, central London, and you see that principle's already in place. And is it equal opportunities? Yes. In fact, the former Home Office minister said it was a lifestyle choice that certain people were out sleeping in the street. There's a trickier one, of course. We want one of your chambers of your legislature to be unelected. We've got a problem with that. There's a kind of democratic deficit here because the House of Lords, you can't vote them in, you can't vote them out. And so, okay, so we may have to give up on that. Right. What's the point here? That you have a reasonably well-respected rule of law, constitutional democracy, separation of powers, legal affordances, etc., etc. And yet, if you were to apply even a rather liberal, never mind a socialist account, programming through this, you would have to overthrow the system. That's not a bad thing. I don't know. But this is the thing. There is a discrepancy, I think, between what we expect the law to do in terms of equality, liberty, affordances, and so on, and what it can actually deliver. Because what you might get from a totally unbiased computer program may be entirely different from what you actually have. And I think, as I say, that's true in the UK context, but it might be worth thinking about in your own. Okay, let me finish here. Perhaps the project of being human in an age of computational law needs to reimagine both justice and law. If designers are writing into the programs the affordances of text-driven law, what are they being asked to do that might continue or exacerbate biases? What is the normal condition that lawyers want to reproduce? Or what kinds of new collectivities and solidarities may be necessary in this new historical era in the way that certain ones were necessary in the 18th, 19th, and 20th centuries? These are large and tough questions, but I don't think the prospects for the interfaces between code-driven and text-driven law can be properly grasped without going forward without addressing them. So let me finish with this. There's an old story. You arrive at a train station in a new town. You've never been there before. You've forgotten your phone, no Google Maps, no access to anything. You go old style. You go out onto the street and you ask someone, can you tell me how to get to such and such? And they look at you. If I were you, I wouldn't start from here. But we are where we are, whoever we are. Thank you.
Wonderful. Thank you, Professor Veitch. Very thought-provoking and provocative and engaging deeply with the themes of the conference. As I said before, let's go one round with the panel, 1 point each. try and limit yourself to, let's say, 1 minute. I know that's a challenge, but that's part of the purpose. So, Sophia.
Well, it's such an unfair challenge, Lawrence. So there's so much in there, Scott, honestly. So I think the is that better? Should I lean forward? There you go. The thing that really stood out to me, and I think it was in the comments I'll be making later, was this quote, Scott, that you made about Newtonian politics for an Einsteinian world. And I do think that at the heart of many of the conversations that we've been having, certainly even in the micro, before you even get to the macro question of what is legal services there for, what does the rule of law deliver to a society, is the vast gap between, as I see it at least, the old world order that we inherit and our ability to then translate that into the world that we are either feeling that we can create, if you feel that you have more control over that, or the world in which some people might describe it as a fait accompli. We are just rolling into a world being created by others who may not have the rule of law anywhere at all in their taxonomy of importance or relevance or design ethic or outcome focus. And the grand scale of the challenge, actually, to hardwire some of these principles deliberately rather than as a sideshow in a sort of accidental way, I think it's central to our ability to form a future that we would want to see, but such a vastly uphill struggle at the moment, I would argue, slightly depressingly. That was my one key takeaway. There is much more to say, but I'll pass on, Willy, to you.
I'm not sure whether I should thank you for that, but I'll try anyway. I think I would like to just point out the last comment you make and link that to this black box society. I mean, we are where we are, but we don't know where we are. And I mean, we don't know exactly well, maybe we don't know exactly what's in that black box, what's driving the black box. Is this black box, is it entropic? Is it an entropy? Is it increasing? Is it decreasing? Are we getting a better understanding what goes into it and what should go into it and what needs to be extracted from it and codified one way or another? So I think for me, I have lots of messages, but I mean, we are where we are, but in fact, we don't know. And we don't know what's driving it, and maybe we should.
Thank you very much. It's very hard even to summarize what's happening in my head in 1 minute after this presentation. What I'm going to try. What stayed with me is the values that we are promoting and the values that we are focusing on. Because from my perspective and in my everyday job, I follow legislation. I followed policy debates, and it's very important to see the imperative that we have from the policy changes and political choices that we are making. What kind of values are driving us? Is it speed, efficiency? Or is it promoting equality, fairness, and how do we do this? And where actually, and this is one of your last questions, where do we see the problem? Because very often what I see is that technology is there, so let's use it. But I think there's sometimes not enough reflection what the actual problem is and whether it can be addressed with technology. Maybe there's something else. So I'll try and elaborate on it a little bit more after the break.
Yeah, I agree with previous panelists as well. I mean, there's a lot to unpack here, but I think I'll align with Willy on this one. So the law as a black box, I think that makes a lot of sense. And you mentioned most lawyers don't know the entirety of the law. They just know how to find it to be able to use it. And I think the same applies to the responsible use of, for example, legal technology. You don't need to be able to program, but you need to learn how to use it. And there's an old saying amongst programmers are not scientists, we're just really good at Google. And I think this is true in this particular instance as well. And it kind of reminds me of a discussion we recently had at my firm. And we asked ourselves, what are we looking for in our junior associates? What are we looking for in our trainees? And your concept resonated with me because it reminded me of who do we want at the, at that interface? Who do we want to see using that? And I think what we should be looking for is the text-shaped lawyer, and try to identify what does that text-shaped lawyer look like, and what kind of skills and knowledge that this person needs to have.
Also difficult to compress things, but I'll try on just one point, really. I thought it was very interesting, that idea of, the rule of law and tempering it and augmenting, that through this process. And I think that when we look to involve technology into law, we are really finding out what we're looking for in law itself, and the rule of law itself. It forces us to look really carefully at the mechanism of human-centered justice and human-centered law. And one of my perspective as a kind of lawyer, practicing lawyer with a kind of now moving into the academic sphere, is that we need to look at why human beings do adhere to the law, and what they understand by the law, sort of using some of the social science techniques of Tyler to try and understand how they actually physically do that. We can't assume that law and justice is going to continue as it has been seen previously. Will we have the same entities and individual roles, of lawyer, judge, etc., as we proceed and justice is reimagined? And I just wanted to leave with one thought from a colleague of mine at King's, Robert Blackburn, who talks about technological management replacing law. And the risk of that, risk or opportunity depends on your viewpoint. But if you can't drive the golf cart out of the golf course, which is one of the examples he gives, they have no need of the law. So this is probably coming back to a lot of the other thinking that's been going on. But that's my point.
Thank you very much, Scott, for your keynotes. Yes, there are weaknesses to the protections offered by text-driven law. And I would even say that it is these weaknesses that code-driven law and data-driven law sometimes exploit by offering false hopes to gain adoption. Nevertheless, you mentioned new solidarities that are required, and I think they ought to find new ways in which to fix these weaknesses to rebalance the rule of law in favor of the powerless. This is especially true in the case of the redistributive schemes that the 20th century invented, and for which text-driven law still hasn't found a way to truly reach everyone. I mean, taxes and social security. These are often topics which are kind of left out by the legal profession. And if you have a system where everyone needs to interact with the law at least once or twice a year, you can't scale it up the way it should be so that each can benefit from the individual benefits of text-driven protection. So we ought to find a new scheme.
So law can encode unfairness, and I agree that is true, but we have at least Newtonian methods to deal with that. So, for example, there are arguments about the limits of what can be called law, and certain philosophers would argue that at least at the extreme end, it's no longer law. We can see in some jurisdictions, and Europe's a really good example of that, human rights is a kind of meta law that infuses and sort of sits on top of other law. You can have things like juries refusing to apply law in situations where they feel it is unjust. And Mabo, for all of its limitations, overturned Terranalius, despite, over 100 years before that of that being a terrible doctrine. So I would love to move to Einstein and have something better than those mechanisms. But I suppose the first question is whether the Newtonian methods that we have for text-driven law can fail when we are looking at code and data-driven law. So, I guess there's that question of looking for something better, but also at the very least holding on to the kinds of protections we do have.
Fabulous, thank you. We've got time for a couple of questions from the audience. Anyone? Marie wants to ask a question. Who would have thought?
Oh dear.
How do I make this comment into a question? Sorry. Let's say I was, when I heard Denis Merigoux, I thought, is he talking about text-driven or text-driven? But that's a joke. Are you talking about the rule of law? Are you talking about liberal democracy? I always find that there is a schism between continental Europe. So I'm interested in Carl Schmitt, who is very relevant for your Aboriginal question, of course. And then I'm not a Schmittian, but I'm a Radbruchian, and I think Radbruch understands Schmitt better than many. And I think the European understanding of the rule of law is more about the combination of countervailing powers, human rights, and the idea, the Fullerian idea of abstract legal norms that must be applied in an equivalent manner. While the Anglo-American discourse about the rule of law is sort of, if I may say so, contaminated or confused with a discussion about liberal democracy. And there we have all the capture by both law and economics, old style, so game theoretical problems, and new style. That's the nudge problems, and I would agree that text-driven law affords a lot. It affords horrible things, and it affords great things, and we seem to have come up with something very imperfect, but I do think it's the best we have. But before going to Einstein, I think Einstein, as far as relevant here, is about the subatomic level, and I can't live there. I live at the Newtonian level, so I need to I need to take into account the Newtonian constraints. So the interface in the project is the concept of legal protection by design, and that affirms writing down a law and enacting it will not suffice. We will have to reinvent legal protection, absolutely. And what I love about your keynote is how are we going to develop that interface between the two? What you call a black box seems to be a vanishing point. So the things you can't see because it's the ground you're standing on. And that has something to do with that interface, but that we need, that we can't just stick to text-driven law. That's the ground I would stand on. We certainly cannot. But then the important question is the more detailed and technical question, where and how, and that's where people get bored and say, oh yeah, well, we'll outsource that. And of course, that's the problem. So lawyers will have to connect with the people who are actually building the infrastructure. Yeah.
Fab. Scott, do you want to quickly respond to any of that, just very briefly?
Just that last point, I think that's absolutely right. Can code build in contestability? I think it comes down to that. And I'm not sure that we would want it to. I suppose that's my point. So that kind of makes us have to think kind of doubly about this interface.
We are right on time. Let's have a quick coffee break, and then we'll return to hear from our panelists once again.
Thank you, and thank you again, both to Scott for his fantastic presentation, and to all the panelists for engaging so well with the keynote talk. So in the final session of today's conference, we are going to hear from our panelists with their sharing from their knowledge and experience on the future of legal method. So each of the panelists is going to deliver a 10-minute presentation, and I'm going to try and keep this to time, so I'll give you an indication when there's 2 minutes left. And we will then, so each of the panelists will deliver their presentation. We will have a roundup of comments from each of the panelists. Again, just a single takeaway from what they've heard from all the rest of the panelists. and then we'll open up for questions from the audience. So without any further ado, I'm going to ask Sophia to present.
Thank you very much. And not that I'm currying favour, but I think in the graveyard shift of a conference, the best thing you can bequeath anyone is brevity. So I will be relatively short and donate some of my time along the panel, and we can pass it on. Let's see how far we accumulate. Okay, so I see at least my comments in two broad categories of impacts on legal method, or one might describe it as rule of law. And now that we had the questions earlier, maybe actually there is an interpretation that is closer to liberal democracy than the rule of law. This I need to give more thought to. But the two categories, broadly speaking, are one, operational impacts, in which in my job at least, I see on a daily basis, and I have done for many years. And the second, rather resonate with some of the comments that Scott was making earlier around policy and ethics. Both present pros and cons. In both of these camps, neither of this is black or white. Most of the approaches that we can take have trade-offs, or at least choices to be made if informed. And I think my macro message from all of this is we need informed policy making. And by that, I'll define what I mean later. Okay, first of all, in the first of these categories, in terms of operational impacts, much of the legal tech that we're seeing or have seen to date focuses on efficiency and productivity, whether that be in civil or in the criminal justice field. Okay, that doesn't mean it's bad. Doing things faster, more efficiently, and more effectively is not necessarily a bad thing at all. It has huge advantages, whether it be speed, whether it be the ability to access something that otherwise would have been beyond the means of a team or an individual to access because of the human resource cost. And we see that in contract management. We might see it through data analysis of huge data rooms. But what I would say is nothing I've seen at all fundamentally rewrites the way in which legal method is delivered, really, at scale. And why is that? Well, partly because that's not where the money is interested in following. So much of this is, Mireille, you made the comment, outsourced to private entities that have a profit motive. Of course they do. We live in a market economy. And the ability to then identify, define, build, test, roll out, we'll find a customer base. And where we're seeing that is in the main looking for tools which deliver the existing methods of legal operations, but in a more efficient way. Because where is the R&D benefit in rewriting the entire rules of the game? Whose interest is that in? And it's in someone's interests, i.e. the collective that maybe as Scott's just described, we don't actually have a representative body for, okay? So society as a whole. And that somewhat will relate to the last point I'm going to make. This said, if I had a magic wand and I had the potential at scale to deliver some of the efficiencies, some of the benefits that we're seeing in the day-to-day tools that I now have sitting in my tech stack or the tech stack that we use for our clients, could I solve the huge access to justice backlog? Yeah, I probably could. Does that bring a benefit? It brings an enormous benefit, because actually in societies where people do not feel that their rights are enforceable or protected, therein lies the rot to either, one might describe it, the rule of law, or actually most importantly, civil, liberal societies. And I defend a liberal democracy. I think living in a world where we have the ability to have freedom of speech and choice of our political leaders and so on and so forth is a thing to be defended. But that only works if society actually feels it has a role to play in the outcomes that the individuals see on a day-to-day basis or collectively are accessible to them. And actually just think of a world where if we could bring these efficiencies to bear, what that might look like. We wouldn't have pro bono clinics, wouldn't need them. We wouldn't have, in the UK, we talk about legal aid deserts. We wouldn't have a complete gap between these so-called rights that are protected and the complete inefficiency of the system to afford access to that at all. And I think we talk about it in such a blasé way, access to justice, but if you think about it fundamentally, there are serious harms being embedded as norms, actually, Scott, resonates entirely with some of the things you were describing, as norms within our society, and we've sort of accepted them after many years of it becoming the thing that we see on a daily basis and no longer challenge. In the second category around policy and ethics, as I describe it, again, there are huge benefits. But what I would predicate all this by is one simple call, or at least a description of the driving force, which is there are benefits if the thing that we are trying to create, or the thing that we're trying to deploy, or the improvement and innovation that we are trying to deliver, that is designed or sought after with a goal in mind, which is around enhancing the rule of law or enhancing citizenry's equality or society's fairness, rather than the goal being, which I think is the case, a micro goal of here is a thing that I've created or I'm able to deploy that helps me deliver my justice system quicker because I just haven't invested in it as much, or helps me to look at the ways in which we might police certain sectors of a city. Now, if the goal, the primary goal there, was to design a system that dealt with the inadequacies of resourcing of policing, would it look exactly the same as the design of a system that might have been predicated on strengthening the rule of law? I argue not. And all too often, the conversations that I hear and see in the innovation world tend to be focused on what I might call the micro near-term goal, rather than the contextual macro purpose beyond which, actually, if we were able to set our sights, we may well be able to deploy changes in legal method that are hugely beneficial. Without being too depressing, I don't see that happening very often. So another way to describe that point might be if we were to take a fundamental rights approach. So even if you don't want to think about goals, maybe we could say, are there some rights that we might want to enshrine within our consideration of the purpose through which we develop or deliver innovation in legal method? Either way, the point that I'm trying to make is I think the reason for doing makes a huge difference to the impact it has in legal method. And at the moment, there is a real gap between the development of some of the legal technologies that we're seeing in play and what we might call the higher goal that we ought to be more concerned about or explicitly concerned about. The second point I wanted to make was around parity of arms in this sort of section around policy and ethics. Whether it be in civil or in the criminal world, the affordability or accessibility of these innovations in legal services, they favour the greater party, whether that be the state or whether it be the better funded. Now, the critique to that is, well, that's exactly what happens already, right? So, whoever has the most money, the deeper pockets, the greater asymmetry of power wins out anyhow. My concern is that, and in no way do I think that this would necessarily correlate so directly to Scott's points, those baked-in inequalities that we already see become superimposed, and unquestionably so, in a way that we then, because we have such a deference to the ability to say, well, it's been sort of circularly supported by the fact that it's happened before, therefore we are going to bake it into the system that we have now. And now it's delivered by this objective, omnipresent, omniscient sort of technology that can't possibly be questioned and can't be as full of flaws as the human might be. And I think that bakes in a huge fundamental worry around the ability for these tools to deliver a better legal method. So the question in the exam question here is, what is the impact on the... Surely our goal should be to improve the system that we have, not to bake in what we already see and or make it worse. Two last points. The first is around quality of decision making. And again, I see huge amounts of improvement. So whether it be the ability to look at huge loads of data, which the human capability of doing so either effectively, i.e. spotting the 10 mentions of a particular jurisdiction, for instance, in a data room the size of here, or doing that at speed. Of course, the sort of operational delivery, the mechanics of accuracy are improved and have been improved. We see it on a daily basis. We've done some really interesting work in my organisation where we've used data science to understand, to see beyond the facts as they may be laid out, to understand an issue at a level that actually we would never have seen before. Augmenting law with a deeper understanding of the world around us by taking extra data points to enable us to flourish in the understanding of that context. I think that is it's a great, to my point earlier, it has bettered our decision making. But also I see many examples of where actually the ability to apply critical thinking to either decision making or the process of decision making is woefully absent. And partly that's because we don't have a skill set in the current legal community. Sometimes it's because you have systems that are, to the point made earlier, that are designed for a slightly different world. They don't allow for, there is not a moment in, there is not an opportunity to, there is not the language for. And this causes me some concern because I see it. I mean, it is true to err is to be human, right? And we kind of imagine that if we could remove the human, we could remove the error. And I think, as Scott has described, actually, maybe there are a whole host of things where we don't need to remove the error. The error might be exactly what society needs. And I think that decision-making, the nuance, the roundedness, the 3D of decision-making in legal considerations is not understood deeply enough in the common delivery of legal services and is lost very easily when we see things in 2-dimension. And my last point, which is probably my most important point, so I should maybe have not left it till last because you might be asleep by now, which is I'm not entirely sure that we have a true understanding of what we want our legal services to deliver in the future, or what it should look like, therefore, as a consequence. So what I mean by this is, if with all the might of our computational capabilities, and I'm fast forwarding a few years, I'm not talking when I leave this afternoon on the Eurostar, but we fast forward a few years, with the might of our computational capabilities, with the wealth of nations that we have, certainly in the global north, and our ability, and indeed our duty to support the global south, would you really design a legal system that looked like this one? Maybe not. Maybe we would. Maybe Scott's made me pause, but maybe I would, but maybe we wouldn't. And maybe actually we deliver too much of a legal system that's based on supporting the rectification of harm after the event, rather than trying to find ways to ensure that in society we prevent those harms in the first place. I don't know the answer to what that might look like, but it's a question worth considering.
Thank you very much, Sophia. Willy, I'll move straight to you.
Good. I'll try to present to you a practitioner's view. But before that, I had a few questions in a way. I mean, one was, what do we mean by interdisciplinary? I mean, here, the idea is we have IT specialists and we have lawyers. And I was wondering, where are the economists or the policy developers? Found out that the economist is sitting next to me. I mean, I saw now Adam Smith. Anyway, I was also wondering about the computational law on edge. What means edge in this? Is this like you? Well, I mean, there are the IT people. Is it like edge computing, something which you do on the law itself, or is it more the computational infrastructure? I mean, what is it? What we mean by it? So to let's say, I have a few points that I would like to just make. Well, it's a practitioner's view. It's giving my own understanding of what let's say computational law is, and I'm taking a very broad definition of of computational law. So, well, I'm I'm an active senior now in the European Commission. And what one of the things the European Commission does is it draft laws. It is very heavily involved in rule making. And I understand there might be a difference between drafting law and rule making, and this subtle difference we need to take into account. But by and large, my experience is more in policy development. So the first point I'm trying to make is what I didn't attend the 2 days. I only attended today. So what I was missing a bit is where is the ecosystem on lawmaking? I mean, we now see we're working on at the end. I mean, on the edge maybe where the law is being rolled out or something like that. But if you look, for example, in the decision making or lawmaking in the Commission, and I guess in many administrations, it's about it starts with citizen business consultation. It has something like an impact assessment. There is a drafting consultation within the organization. There is the adoption process, which involves political decision making. I mean, then, at the European level, you have the involvement of the other institutions, another political discussion that comes in. All along the process, you have something like have your say, where any European citizen can just comment on what is happening. And then once the law is out there, I mean, there's the implementation which is happening, and there is the evaluation. So it's a whole process. Are we talking about computational law in this complete process? And one of the terms that have been coined in the Commission is this better regulation, simpler implementation. And that is something which is, to a certain extent, driving what I'm going to say. In what I indicated in all these steps, one element, and that goes to efficiency, is something like machine-readable law. I mean, we have all these bodies, these thousands of people that might be involved at a certain moment in time, and you all have to work on the same readable document. So, I mean, there is this stream that you can seamlessly interact with the other institutions, with member states, with the audience at large. So, I mean, that's something which is important. So that's the first thing. So we have to see things as more of an ecosystem. Now, when I was explaining you the ecosystem, it looks like a single process. It isn't. I mean, this lawmaking process is several processes that run not one after another in parallel. There are several artifacts that are being produced. It's not only the law that is coming out, but it's all the secondary information that gives you the interpretation and what have you. What we think is that if you consider all these processes, these artifacts, obviously IT computation can help. We see it very much as IT should augment what is being there. It's not replace it, it's about augmentation. And if you want to augment, you need to take into account a number of, let's say, boundary conditions, if you want. I mean, I think lots of people have been talking about the specificity of law. Law is different from rules. It needs a little bit of interpretation. It needs to be vague sometimes. Sometimes it's better not to regulate, etc., etc. So you have to have this vagueness, and when you're designing your IT environment, you have to take that into account. So I would advocate here, it's not like something one size fits all. I mean, there are several pockets of law, and for some, maybe code-driven law might be better. For others, it's just don't give it a start, maybe. But we also see that, and that's very visible now is all these new technologies that are being introduced, these large language models, generative AI. But not only that, I mean, there's also this hybrid AI and what have you. And that brings along a new requirement, if you want. I mean, we need to make an assessment on what are the benefits, what are the risks involved, what are the limitations that we have, and how are we going to deploy all this. I have to go fast. All this need to be implemented by people. I mean, lawyers, IT specialists, economists, they are real people. We are talking about a real cultural change. We are talking about digital transformation. And what all this needs in administrations is guidance on how are we going to deal with this? And how are we going to develop this guidance? The only way you can develop this guidance is by piloting it, trying it, testing it, evaluating it, and what have you. Now, the reason I'm called, I was invited, I think, is I'm working on I'm co-working in the Commission on a system which is called LIOS. It's a drafting tool. It stands for Legal Editing Open Source. And it's something that will digitally transform. And maybe I'm exaggerating, but I'm allowed to do that. Digitally going to transform how we are going to develop legislation in the Commission. It's really a huge project. I mean, just to give you a few examples, I mean, one is, I mean, the idea would be that, let's say, all the decisions belonging to a single law would be available in a single space. All that data would become available. I mean, just suppose you would have such a thing. I'm exaggerating, but I mean that's one of the ideas that we might have. We're also looking into, I mean, it's about efficiency, but it's also a lot about quality. I mean, if you take a typical legal act can have something like 5 or 250 articles, makes reference to let's say 200 other policy documents that somehow are related. And how on earth are you going to manage this? I mean, AI technology can be of great help in that. So the question there is do we go from an editing system to a real smart drafting system? And how would that look like? I'll try to finish now in 1 minute. This is about law as code. And it's also, when I talk about drafting, I think here you're talking about design. So it's we do things by law as well. We do things by drafting. Here you do things by design. Now, I would like to point out one policy, which is this digital ready policy. So how can we design, or how can we draft laws that can be more easily implemented? And it's not only about easily implemented. I mean, how do we ensure that, for example, the reporting requirements, the economic cost of something would be minimal, but still valuable? How do we do that? It's also about, and there you then go into this element of this once only principle. How can we reuse data so that we're not asking everybody always to re-enter the same data, but can we have a secure means of reusing data? And hence, we're talking about the rollout of services, getting benefits for society, for businesses. How can we reduce the burden? Last element that I'm not going to embark on it. We're very much promoting open source. And open source comes with transparency. What we do in the development of LIOS, for example, is we tell everybody what we're going to develop. You can see the code. You can play with it. So we're really having let's say an open source approach. And then finally, just to end up showing that I did informatics about 30 years ago, so I was quite intrigued about this test-driven development. It sounded a little bit like in modern terms, but not for programmers, but for linguists, as prompt engineering. I mean, you just say, well, this is what I would like to come out. You develop a prompt, see whether it happens, and then you start refining it. Just as a final remark. So what I wanted to say is this is about an ecosystem. It's about efficiency, it's about quality, it's about delivering services at an economic cost to the benefit of all. Thank you.
Thank you, Willy. Anna?
Thank you very much. Can you hear me? Okay, well, I'll keep talking and we'll see if the microphone works. So, first of all, well, thank you very much for all the ideas, and I already have a couple of responses to my predecessors. I'll try to address them in my short intervention. So, I come here as a representative of an organization that represents bar associations and law societies, and of course, as such, we represent practitioners. So my view is like, of course, it's where we're going, what's the future? But actually, in my everyday work, I'm focused on what's the actual practice today, you know, and how the use and take up of new technologies shapes the way we actually draft new legislation and shapes the legal practice and what impact it has on some core values of the profession. And well, in my everyday work, our focus is always what kind of values we are promoting here and what's the overriding drive to digitalize digitalize policies and digitalize the delivery of justice. And of course, if you can deliver better and faster justice is great. But we also, and we always caution against that. We always in our work, in our policy work, in our papers, we always draw attention to those core values of the justice system that have to be upheld now. That rollouts of digital systems cannot endanger fundamental human rights such as, right to a fair trial, presumption of innocence, protection of confidential nature of lawyer-client communications, and this is all that we try to stress in our work, and we have a lot of work when it comes to new legislation and policy. The current legislation of the Commission and the Parliament has actually enacted and still working on some of the major pieces of legislation. One of the most recent ones is AI Act, where the debates are really they are very intense, and it's like a moving target because between the publication of the proposal and right now, there have been some important developments in technology. And there are some fundamental questions, but also hearing the discussions here and many like philosophical questions and big concepts that we discuss. I'm sometimes thinking, how do these get into the policy making and the choices that we make as as organizations, as practitioners, but also ultimately, how do they get into the political process? Because I sometimes feel, and we discussed that yesterday, how do these two worlds connect? And this brings me to the organizations like mine. What we try to do is that we try to get the combined experience of practitioners and inform the policy world and inform also the academia, how things work on the ground and how lawyers actually work with these technologies and how ultimately they are being taken up. There's one thing to design some systems and there's another to actually put them into practice. And many of you know, you have something new in your own company and you start using it and suddenly it's not used. Why? Because your current way of working is very different. And you would have to fundamentally change something completely else. So actually the key to take up of some technologies may not be in the technology, it's how you work. And how you interact with these systems, how you learn them. And that brings me to a very big challenge, and some of you mentioned it throughout the discussions today. It's the education system as a skill set that we need. It's interesting that Sophia asked the question, with all the resources that we have, would we design the legal system that we have? That's the question that I usually pose about the education system. Knowing what you know now, looking around, would you have the education system as we have now? I don't know how about you, I spent quite a lot of time in chair, listening and reading stuff. Whereas actually there is so many other skills that you should be having. You should be working with things rather than reading and listening about them. There are plenty of people who actually learn better through doing things, through moving, just going back to such basics. So I think this is a big challenge for many organizations, including my own, but also for ultimately for policymakers, is actually how to design systems and not design systems as they are right now, just to learn for once and use it throughout life, because that's not how it works, because the world's changed and we have to learn all the time. So how to build in that the constant learning into legal practice. And again, organizations like ours try to support the practitioners with guidance, with information, what's happening, and kind of give them advance notice of the trends that are present, so that they can prepare and they can adjust as much as they can their practice, and to look out for trends that are coming and how to respond to them. And of course, it will be different from sector to sector. And I think that, sorry, I have so many things that I want to say that I'm struggling to choose. But I think I'm going to give time to my co-panelists, and perhaps we can then have a discussion on some questions to each other, because I think there's so many perspectives to engage with that perhaps it's better to listen and then to talk about them. Thank you.
Right, halfway, everyone. Bear with me. Leave you with today, or I'll be here for the drinks. The idea that I'd like to impart on you is that legal tech will influence the advice given by private practice, but I do not think that is a new risk. I'll get into the whys as we go. So the first thing that you need to know is that we as private practitioners are being wooed. Legal tech is made sexy for us. It is really, really sexy right now. We were talking during the break about fancy presentation tools and promises of so much more revenue and so forth. It promises to make our life more fun as lawyers, and lawyers always like to have fun, right? It promises to speed up the delivery and the efficiency. Now, there's a comment to be made about lawyers wanting to, is there a perverse incentive to speed up delivery, or is there a perverse incentive to slow it down, which is the big elephant in the room of private practice, and it's called the billable hour. And I'll get into that later too. Legal tech also promises to improve user experience. So it promises to make the life of our clients much better and much more user-friendly. But I think the main thing that we can take away from that as a fairly conservative society is that it will ultimately help us shift away from the billable hour. And I only recently heard that this is being recorded, so I'm sure I'll get some flack about this from private practitioners elsewhere. But I think it's a good thing that we're moving away from the billable hour. I hope that wasn't too loud. So legal tech is definitely something that private practice is looking for. My firm has adopted numerous legal tech tools. I know other firms are doing this, Simmons and Simmons. Major firms are looking at legal tech and have been looking at legal tech for quite a while now. But it's picking up pace following the huge introduction of, for example, generative AI and the availability of large language models like GPT. I don't necessarily think it will bring new problems. So I think the problems that we'll face with adopting legal technology are more of the same, but the scale and the frequency on which we see them, that's what's going to change, and that's what's going to drive us to ultimately require more regulation and adopt countermeasures to protect the rule of law. So legal tech needs to be implemented responsibly. It needs to be implemented responsibly, and we will need to protect ourselves against the power of tech vendors, small and big. And we'll need to educate lawyers about how to use this technology. And I'm always reminded of the concept of T-shaped lawyers, which is something that was quite big and preached while I was in law school. And they said the T-shaped, is everyone familiar with the concept of T-shaped lawyer? So broad, you know a lot about a lot, but, or you know sufficient about a lot, but you know a lot about one particular thing, right? So the T, you're very broad, you know a lot about a broad field, but you are an expert on one. The T-shaped lawyer as the ultimate trusted advisor. We sort of got into this during the keynote comments as well, because it makes you wonder, what do we need to look for in the next generation of private practice, in the next generation of lawyers? And I think you could argue that you could look at technology, legal tech, as your virtual trainee or your virtual junior associate, which means that you'll apply much of the same checks and balances to your virtual assistant as you would your junior associate. You would say, I want to check your credentials. Did you actually go to law school? Do you have a permit to work here? What is your motivation to perform? How do you perform? We need to allow legal tech to work and to learn, and ultimately, but we'll need to check the work product, which is not different from what we do with our trainees. I mean, we always say we assume that you know nothing when you get out of law school. But you need to be educated. It's training on the job. And ultimately, you need to have kill switches. And I mean that in the most friendly way possible. But if you're not performing, then yes, there needs to be a leverage if you're stealing client secrets, or if you're simply underperforming, then there needs to be an option to terminate your employmentship as well. And what it comes down to is quality management and risk management, which is something that we as lawyers, I think, are very good at preaching about, but very bad at implementing, because it's not our job to implement that system, right? Do you know who implements that system? It's auditors. So as lawyers, we could probably be, I mean, I'd like to add to the, we're missing economists. Well, apparently we have some. We have technologists here. We have lawyers here. Perhaps we need auditors here as well. Because they're the experts at implementing this and making sure that your compliance systems are to speed and checked frequently and monitored. But this is all easier said than done, right? Because when I was talking about that junior associate, how to check his or her credentials, how do you do that for legal tech? What are the appropriate credentials for legal tech? And how do we check things like data quality and stuff like that? Where are the industry standards right now? I mean, we have a lot of people working on that right now. If we look at the AI Act, for example, we have Senelec that has been commissioned to draft a huge amount of technical standards for AI, but it doesn't necessarily cover legal tech in the broadest sense. And how do we work with incidents? How do we separate risks? Because ultimately, as a private practitioner, you also need to be insured. And in fact, I would argue that we are one of the best targets to sue as a client, because usually we have really strict limitations on how much we can limit our liability, actually. But insurance for our virtual assistants, interesting. I'm not sure our insurance actually would cover that. So my prediction is that we will see the first insurances for legal tech quite soon. What you could see is some private practices saying, you know what, I'm going to separate my legal tech activities into a separate firm, which is something my old firm did and was actually received a stern talk from the local bar association, because they said that might conflict with your ability to provide independent advice. So if you're working with tech tools and providing tech consultancy on those tech tools, that might influence your ability to be independent as a lawyer as well. And there's an argument to be made, and a stronger argument, I think, against. Now, what I think we need new rules and regulations, and that means statutory rules, things like the AI Act, which we're working on, of course, but these are not without issues either. Has anyone looked at the AI Act or at least one of the drafts? Then what you'll probably notice is that the rule of law is there in the AI Act. It is considered. But if you look at which group of law practitioners is considered there, it's the judicial authorities. It's not private practitioners, right? So their high risk is an AI system that is used by the courts, not an AI system that is used by legal practitioners. So we need standards, and I mentioned Senelec, but we also need guidance from bar associations. And in fact, the American Bar Association just came out, I think yesterday, with guidance on how lawyers should be using generative AI tooling. And we may also need to update our clients on that we're using their data for generative AI purposes as well, because it might benefit them, and it's scary. But the main thing that we need to do is educate the people using these tools. We need to look for who is the we that we're talking about. Who is the we that we need for the future? We need to be looking not for the T-shaped lawyer, but the tech-shaped lawyer, and providing them with appropriate education from the ground up. So we need to look at this from a university level, but especially from a vocational level in private practice. All right, thank you.
Thank you, Martin. Cari?
Hello, yeah. So I'm mortified to say that I have slides. I obviously just didn't get the memo that we weren't using slides, so I really do apologize. But you'll have things to look at. So really yeah, there you go. So the way you could think about this piece that I'm talking about now is almost like a love letter to this whole project, okay? Because that will become more clear as I proceed, okay? So when you think about law, obviously there is that feeling that there are rules. It's easy to potentially put those rules into code. That's a very basic way of looking at it. Of course, that's been looked at in much more detail through the course of this conference. If we could turn to the next slide. This was, this tool will trap liars. This is in relation, spoken about a tool used by the police in Spain, and it was used to look at reports to the basically reports to the police that might have been used basically to obtain insurance, sort of provide a police number to the insurance so they could recover money. So the idea was that you can build a tool that looks at language used that will assess whether someone is lying or not. And this very much goes to framing this whole conversation into this idea of omniscient tech that was spoken about earlier, and the media's perception of this as being extremely helpful. And if we could move to the next slide, the Veripol software then was judged to be a kind of 80% accuracy. And was said to be working very well. Scientists have come up with a way to tell if someone has lied, on a police statement. But if you dig into this, and this is why it's a love letter to the whole concept of this, you really need an interdisciplinary analysis to understand how this tool is failing. Yes, it had an impact, whether that was kind of a placebo effect. But essentially, the things that told you whether this person was lying or not was Were they using complex sentences? If they were, then they were less likely to be lying. Were they using words like aforementioned? Okay, this is in Spanish language, so it's slightly different, right? But aforementioned suggests that you're not lying. Okay, and then when you look at how the tool was trained, it was one policeman that looked at 1,000 records and decided whether they were true or false. So you see here how tech can put an air of objectivity, that it's, it knows, it can tell, and this is how it's reported. But when you then look at the minutiae, when you look at how it's functioning, you find that it's not actually as it seems, and it's just replicating biases. That's all it's doing. Not to say that all algorithms are the same, and that's not what I'm trying to say, okay? But it's this awareness and this need for interdisciplinary approach. And why is that so important within the justice systems? If we could go to the next slide, sorry. So I don't have an example from a justice system. I have an example from the UK, and an algorithm that was used to decide the outcomes of exam results, okay? And so you had these big protests because what was being done was using statistical analysis, again flawed, to look at whether someone was likely to get an A at the A level, right? Just before they go to university. And of course, it created a sort of wholesale undermining of that system. What I say is I draw that that parallel to say, we don't want this kind of protest happening in relation to the justice system. Because the rule of law and what all these concepts that we talk about are not just based on have we got a set this certified through legal channels. It's also to do with the support of the people in relation to it and their response to it. If you could get the next slide. So this is a less beautiful picture, and unfortunately, I don't know if you can read it, right? But it's my very poor illustration of basically Tyler's work on why people adhere to the law. Why do they follow the law? And this is from originally done in a kind of American context. So yes, we need to think about context when we're looking at this, right? But there we're talking about is what is the quality of the treatment like? What is the quality of the decision-making like? That feeds into the perception of legitimacy of the system itself. And from that flows all the cooperation with the authorities, and from it, the policy, the success of policymakers' policies. So if policymakers, we want to speak to policymakers, if they want their policies to be implemented, then we need to think about how law is perceived by people. If you get the next slide. Sorry. And so when we talk about black box justice, I think it's a really valid point that Professor Veitch made, that we're not just talking about black box in technology. There's also the aspect of the fact that in justice as it stands, there's a serious black box, okay? And that's why when I talk about legitimacy, it's a kind of measure that is across algorithms and human-driven law, right? And it's not something specific, because we have to recognize the issues that we have in law as it stands and in the justice system as it stands. So we need a way of dealing with this in an interdisciplinary way, to look at law as a whole and to understand where this black box problem is coming from and how we address it to ensure that people are following, that people feel included in justice. So this image was produced with a collaboration with myself and an artist. We created a kind of 3D environment, okay? And the idea behind that is communication with the people, right? So communication with different groups of people, different backgrounds, to ensure that we can have a conversation about these ideas in an accessible way. Because if we cannot understand each other when we have these conversations, then we can't work towards a solution together. Yeah. So this is just to give an example of the kind of things that we've done together to try and work at, explaining various concepts in kind of workshops and workshops, and we want to advance it further, where we involving the public and other groups. So I mean, by other groups, I mean judiciary, legal experts, technical experts, in having a broad conversation across these ideas. Because the idea is ultimately we need the public with us. And I'll explain a little bit more as I go on. Sorry. So Ruben Bin and et al. Talked about this idea, right? It's reducing a human being to a percentage, okay? And yeah, that's okay. So we need to understand what's going on here. Is it just explainability? I'm not saying just, but it's more than just having open code or being able to have various explanations. More is going on there, and we need to work together to understand exactly what that is. But interdisciplinary work is hard, okay, and it's tough, and this is why this is exactly the kind of forum that we need to work in. Ultimately, I'd say that justice is more like a porous membrane, okay? We need to understand what the values coming from the people and be ready to correct when law goes wrong. How do we maintain that when we involve technology? Are we going to be able to do it better, in fact, when we involve technology? Possibly, if we work together, and so there is hope, okay? So this is what we need to focus on, that hope of communal work towards it. So I'm going to skip, I've got 2 more slides, but I'll go through them quickly. Yeah, so this is the kind of work that I've been working on, kind of testing responses to particular technological innovations, right? So like seeing how people respond to an algorithm, making a particular decision, and then saying, well, actually, a human made that decision. Do you feel differently now? Why do you feel differently? And of course, there's a mountain of qualitative data that can be assessed with that. So one of the main things I'm seeing coming out of it is it's not, even though it may be a low value, low importance, just sort of offense, like a traffic offense, that's impacting a lot of people, and it's affecting, it's causing people to feel a great injustice. Last slide. I'll skip through this, but there are ways in which we can work together and discuss these issues cross disciplines. So I'm very happy to talk about this image more, but I think I've reached my limit. So thank you very much. I could talk about education a lot, but that wasn't in my preparation. Maybe later.
Thank you very much. I'll try to keep it short, right, in the interest of time and general attention. So I kind of bounce back on the comments by Willy saying that, okay, we have this complexity that we have to handle in the real world, and we're going to need some kind of computer systems to help us do that. And in some domains, yes, you will have to use these computer systems. And the question is, how do you do that properly? And I have the impression that a lot of attention from the legal profession to legal technologies comes from a sort of a general sloppiness around the evolution, the quality, and the effectiveness of these technologies. And there's this idea that, oh, software is always buggy, software always can err, software is something that is always unreliable, that is impossible to control, etc., etc. And this is, of course, directly against the criticality of most legal applications where the computer systems involved in decisions that can affect people's health, financial records, life, etc., etc. And my colleague Liane Huttner makes this point very well in her PhD dissertation, also in her speeches. So then how do we do? I mean, is it inevitable that all computer systems cannot be trusted and or in this kind of horrible states? And I would object to that, because as soon as computer systems were used after the invention in critical applications, there has been a formidable amount of work that has been put into building methods, both technical and organizational, to make sure that software doesn't blow out and computes exactly what you want it to compute and without any errors. And then when you reach that state, the computer infrastructure that underlies your service becomes invisible and you don't hear about it at all. And this is the case for several pieces of infrastructure that you use every day. For instance, the DNS internet system, you've never heard of this, and it's because it works. It works so well that you don't hear about it. But there's a whole body like ICANN and a body of engineers that are dedicated to maintaining it. But in the end, it works, so you don't hear about it. And there are other things like that. When you use a train or a plane that's got the avionics or train software are subject to very high level of quality and they don't fail, so you don't hear about them. Same for nuclear power plants, etc., etc. These are the traditional domains where software production and maintenance, high degree of assurance has been developed and methods have been developed over the years. And it is possible to produce and maintain software with a very high level of assurance. It comes with a combination of software engineering, maybe a little bit of applied formal methods, but also good governance around what the software is supposed to do. And I would say that the computational law engineering community should take a little bit of this culture and try to integrate it into its applications. Because if you're staying with the ideas of the disruptive self-taught programmer that's going to revolutionize your legal app by this startup, and of course, this self-taught software programmer is not exposed to the culture of critical software engineering that is enforced in other domains. So I really think that we need to incorporate that culture into the computational law. And I would even go further and say that impactful legal technologies are operating mainly by centralized entities, and the first of which being the state. And I think that in order to foster that safety first and very high level of assurance culture in their software application, these large organizations should create this professional class of computational law engineers that have this culture of safety and we both need to have a very high level technical level of assurance, but also a high level of assurance that the rule of law is compliant. And I mean, the software is compliant with rule of law and not the converse, right? And you see that most major software companies already know that, and the critical functions inside the big software companies are already assured by these very experienced, very knowledgeable software engineers, which they retain by giving them astronomical salaries because they don't want them to go elsewhere. And I would end this argument with a metaphor, because there are other professional sectors which, as engineers, have developed this culture. You can say civil engineers. You're not going to have a bridge built by somebody who's just, I don't know, out of landscaping school or out of law school, because this happens in some administration. There are some engineers working on systems that have been recruited and that don't have any training in software engineering, for instance. This is the case. This happens because when there is no professional recognition for the people doing this technical work, then you'll have like sort of anybody coming and do the job because the job has to be done. So this is my main point. We should have computational law engineers, and this should be recognized like sub-trade in computer science. And big organizations, and first and foremost the states, should foster the development of that professional community and culture if we want to have legal technologies that we don't talk about because they work.
10 minutes or less? 8. Perfect. All right, hold on. Okay. So I'm going to talk about a project that we did with a couple of partners. So one of our partners was the Future of Innovation and the Legal Profession team at the university. This came out of a Law Society project, actually, which was called the Future of Innovation and the Legal Profession, that the Law Society of New South Wales ran and wrote a report, and then sponsored 5 years worth of research in our university with a team sort of looking at all the different issues, including, yes, the great billable hour. So we worked with them, and we also worked with another organisation, the Australasian Institute of Judicial Administration, which is basically judges, tribunal members and court administrators. And they supported a project which was to create a guide for judges and tribunal members and court administrators around artificial intelligence. And this is often, I mean, this is really a missing gap in education, because a lot of these people, by the time they're in those roles, are relatively senior. When they were in law school, even what little we do have now around, giving students some education in the technological context of practice wasn't there yet. Artificial intelligence is either a big scary thing or a magic wand. And so the question is, who is actually making the decisions about what courts might choose to implement, right? So the guide was to help with that. And so what we did is we started out at the beginning of the guide, just defining concepts, words, what they mean, looked at some of the different kinds of artificial intelligence, affordances and limitations of different techniques at a very, very high level. I mean, this was not a textbook, this was a guide for judges, etc. And then we gave some examples of different things happening around the world in a bunch of different headings. So we looked at, for example, hold on, my notes vanished because I didn't log into them recently enough. Okay, so this was including things like technology-assisted review and discovery, automated online dispute resolution, prediction of outcomes, which is controversial, criminal sentencing and risk assessment tools, automated decision support and decision-making, automated e-filing, triaging and allocation of matters, natural language processing, and we're doing a second edition now where that is including large language models, AI-supported legal research, and we also had a section on rules as code, which was less about what might happen in courts, but more something courts needed to be aware of in order to potentially have to deal with it if it came before them. We then had a sense of, well, what are the values we want to preserve? So we did start with sort of, what really matters. And in the first edition, we've reformed this slightly in the second edition, but the first edition, we had open justice, accountability, impartiality and equality before the law, procedural fairness, access to justice, and we did, I have to tell you, have efficiency as well, because that is a value, and preserving taxpayer money that goes into courts is important too, and certainly a pressure that court administrators are facing. So we then put those together, right? So we looked at the examples of what's happening in the kind of context it's happening and analysed those against the values, where are the inconsistencies, what are the problems, but also where are the opportunities, right? What are some of the really good things that are happening? And then at the end, after all of that sort of analysis, and the report is freely available online through the Australasian Institute of Judicial Administration's website, we decided in the end that the best way to sort of help judges and court administrators, et cetera, was to formulate things in terms of questions. So we had both high-level questions that we said any implementation of an AI system, these are the questions that need to be answered. And then we also had questions under the different sort of domains, right, the different values, because there's obviously specific questions you need to answer about things like equality before the law or accountability and so forth. So to give you a bit of a taste, the high-level questions, we did start with why, you'll be glad to hear. So our first question is, why is AI being used? What problem does it solve? Right. So we're very much about, asking that question first. The next one is the use of AI authorised in the context in which it's being deployed, which it sounds like a very basic question, but often something that certainly in public administration in Australia has been missing. In what context is AI being used, and is its use in those contexts appropriate? Does the context involve high stakes, vulnerable people, novel situations, or high levels of emotion? Right, so another factor to consider. The next one is, how is AI being used? How can system requirements through a procurement process better fulfill its purposes and meet the needs of courts and tribunals, including in relation to core judicial values? How will the system be checked, tested, and evaluated to ensure it meets those requirements, which is some of that, although I like your language better, and maybe we'll put that in the second edition. Who is consulted about the deployment of AI systems? Are all stakeholders, including users and litigants, included in the decision-making about whether and how AI will be used? Will the use of AI impact on public confidence in the judiciary, which we felt was also an important question, because sometimes things can be great and work effectively, but the perception of the end users of the system, if I can call them that, is actually different to everything else. And then ultimately, will the use of AI be accepted by the public? So that were our high-level questions. And then we sort of looked at the specific contexts. And we, but even very mundane examples, we said there's actually really important questions to ask. So automated e-filing sounds very routine. It sounds like something that is completely uncontroversial, but there are in fact problems. Well, there's opportunities too, right? It enhances accessibility, saves paper, it makes documents more searchable. There's the possibility of hyperlinking documents, which means you can sort of move between them more quickly. It can also, check compliance and reduce errors, take steps automatically to enhance efficiency, so automatically sending things to parties and so forth. And there is actually machine learning available that can automatically extract relevant information. That's obviously even better now than it was when we wrote it, and use that to automatically complete other paperwork in the context of case management processes, etc. So fantastic. Two potential problems. One is the legality problem at a very basic level. So if, for example, your automated e-filing system, inevitably, because it's technical, will have to have size file limits, says the document that is being filed has to be under, I don't know, X megabytes, is that actually legitimate? Is that something the court can do, right? Because generally speaking, anyone can file a document in court. Like, can you limit it by technological requirements, even if necessary for the system to work, without having some kind of formal rule on which you're basing that, as opposed to just, this is the tech system's limitation, right? So there's those kinds of issues. But even in terms of things that this system is meant to do, like efficiency, there are questions about the efficiency of the whole system as a whole. So if, for example, not having court staff interact directly with the documents means that you're getting efficiency because you can sack them all, but you're losing the fact that they often pick up issues, particularly with litigants in person, that might help early. Yep, so that's actually stop then, right? That might help early to shape the process. Is that actually going to cause more delays down the line if those documents are in less good shape at the point of filing? So that's a very basic one of automated e-filing. Obviously, the others were even more complex and controversial, and I urge you to read the report. And there you can see not only those high-level questions, but the questions we asked under each of our various subheadings. Just a final line, second edition will be out very soon. So if you want to wait for that, because it'll have LLMs in it, etc., please wait, and it'll be out probably by early next year. And then we're looking to make it an ongoing resource. So moving from a kind of episodic version 2.0 type model to something like a sort of interactive wiki that's easier to keep up to date. Okay, that's it.
Thank you very much, Lyria, and thank you to you all. We asked a lot of you to condense your talk into 10 minutes, and we really appreciate how you've achieved that. I'm hearing lots of interesting synergies between the discussions that you've had, but I'm going to leave it to you to draw that out. So I'm going to give each of you 2 minutes just to either say something that you really wanted to say, but you didn't have enough time, or ideally to pick up on the conversations from the rest of the panelists. And to use Martin's phrase, I'm going to operate a kill switch. So at 12:30, I'm going to give the questions to the audience, but I'll start with you, Sophia, just to pick up on something salient from the conversations.
Thank you. So lots to say, but just a few points to pull out, which I think really stood out to me. I think you can probably, to this question of the impact on legal method, divide the world into the near-term augmentation, what we're seeing in the here and now, which has a certain sense of clarity I'm seeing in terms of where we think we might be seeing adaptations and changes and potential opportunities, but also some of the risks, but with a healthy dose of slow and laggard-like deployment in different parts of the profession, partly because it's complex, partly because we have cultural needs, partly because we have a re-education gap. And that goes right the way through the legal profession. But then we have a longer term, I think, a longer term sphere, which I think is rather unclear. I don't think any of us really have put our fingers on what we think 10 years from now might look like. I think that poses a great opportunity, because if it hasn't been written yet, it means that we can define and set the rules of the game, ring the siren of alarm or raise a flag and be optimistic, whichever way you want to describe it. But I do think there's an opportunity. I also think it's a potential gap. And the reason I say that is to pick up on the point that a number of colleagues mentioned on the panel, which is this point about interdisciplinarity. So it is absolutely essential, I think, if we're to see some of the opportunities that have been identified here come to full fruition, and some of the gaps that were so well articulated by Scott at the start of with the keynote, and also by the comments of my fellow panelists. We really do need to see this as a joint endeavour of law, policy, technology, and citizenry. And by citizenry, I mean both citizens, but also their representatives within the political domains, wherever they might operate locally, nationally, or regionally. And then the reason I say that is because actually none of these issues are straightforward. And I think you've just described really beautifully, even in the most mundane area, there are really complex questions to solve. And I think as a parent, there is no right answer. But there will be a need, I think, in order to enshrine legitimacy in where we arrive, for there to be voices of all in the design of that. And I want to just finish with the point that I think we have an opportunity, but a duty to deliberately seek to design the future of the legal method, rather than simply leave it to an outsourced group of those for whom this is not a relevant question, but rather a simple byproduct of other priorities. But I think we have a duty and opportunity to seek to define that as deliberately as we possibly can.
Good. There are some common themes, I thought, that were both in the administration, the law firms, and everybody involved in legal texts. And that's about skills, education, and what have you. And well, the question that is raised is are lawyers going? Is it going to become a new profession or something like that? I don't know. Probably not. Maybe not. I don't know. So I think the question on what kind of skills would we need? I think the second element that came out clearly is this element of trust. I mean, what's the level of trust we're looking for? If you're going to use something like generative AI, I mean, you know, the outcome is going to vary. But I mean, what variance is society willing to tolerate? I mean, if you know that it's going to be varied, but I mean, what's this cutoff point where you say, well, we can't trust the system anymore? I think the third element, and that's I mean, when I came to the conference, I was wondering, I mean, what is this legal tech community? I mean, I mean, how do we define it? I mean, does it exist? Does it have an agenda? I mean, or who sets the agenda? I mean, what are we talking about? I mean, sometimes we refer to law tech, gov tech. I don't know. I mean, and it looks like there are quite a number of terms hinting at the same thing, but it's difficult to just say, well, this is it. This is the community. This is what it stands for. This is what it influences, what impact it will have, and where it will hopefully guide the process to reach something which is common sense. I mean, not everything which is common sense needs to be put in law, I guess.
Thanks very much. Just three brief points. One, there seemed to me a commonality here about the need for the clarity of purposes or the clarity of ends. And I think Sophia expressed it very well, which is that we also can't think about ends without thinking about the relationship between means and ends. And I think that is a key commonality here, that we think about the ends, the purposes, the goals, but also think about how they integrate very much with the means themselves. Secondly, Denis's point about, I think it's absolutely key about cultures of accreditation. And that would be one form of what I imagine of sort of new forms of community or collective springing up that are going to be absolutely crucial. And in a sense, they may be kind of illegal. They're not necessarily run by lawyers, they're not necessarily run by technicians, but they demand, the problem demands a new kind of space, a new kind of community. But it is about accreditation, as you say. We don't get on a plane, we don't think about the amount of engineering accreditation that's gone on, but thankfully we know, hopefully, that it is there. So I think that's crucial. The final point, somewhere in Mireille's writings, I came across this lovely example about two fish who are passing each other, and one says to the other, "How's the water?" And the other one says, "What do you mean water?" Yeah. And there is a sense of there's a generational question that is arising here. So as Lyria pointed out, a lot of the more senior people in the profession have no idea about these things. Yeah, they've never been trained in them. They come new to them. It's hard to teach old dogs new tricks, all that kind of stuff. I wonder whether, in a sense, what we're thinking about are not fish so much as amphibians, right? So that we have groups that are both able to live on land and in the water. And that's the kind of legal education model that we want going forward. Just a thought.
Thank you very much. I mean, I was very interested in hearing the presentations about the guide, the project in Australia, because this goes back to a lot to our work and our discussions and what we can do right now, and how we can accommodate the developments that have been taking place already with the actual practice, and what kind of values and key principles are engaged so that lawyers actually pay attention to them. And Martijn actually mentioned some of them, especially something which is absolutely core, such as independence of legal advice. And ultimately, we go back to how legal professions is regulated, and it's regulated slightly differently in every European country. Of course, there are commonalities, but there are very different approaches to what legal advice is. Can legal advice be given by a machine, or should it be given by human? And there will be different responses to these questions, or different preferences on how to respond to it. And I think this is something that is one of the questions for the future. A lot of questions arise also. How do we treat confidential information, and how we use new technologies without compromising it? And again, goes back to the education and to know what kind of technologies we are working with, what kind of risks they carry, how to use them safely, but also how to approach them, how to examine them, and how to check how they really work. One of the such examples is where data is stored and what kind of regulations apply to it, and how safe the data is, and how protected it is from unwarranted disclosure. And this is actually one of the big problems that the legal community is facing, and there are many questions of the regulation of the profession that actually arise in the context of technology. Also, because as some of you mentioned, we are talking about different communities. One of you mentioned different legal tech communities. They will be different because they will be that they arise from different needs in different sectors. And I think this is one of those interdisciplinarity questions that we have to look at in the future. And one final comment, it's a personal one. So my partner is a software engineer, and we have very, very heated debates about artificial intelligence. And what I actually got from these discussions is that there is a big gap between us. And it's not because we don't know what we're talking about. It's because that common ground is kind of missing in a way, because he has like several tabs open with some codes and everything, which I don't really understand. And where he is looking at the legislation that I'm reading, he said, what is this? And we have tried to actually reach that gap, and we decided there are actually several levels of understanding that have to be bridged. So it almost, what you were saying, Martijn, about the tech lawyer, it's almost like one person has to integrate several types of skills in order to be able to kind of translate it and to bridge that gap to be able to communicate with another. So I hope this leaves with you with the good conclusions that we will have to have more skills than one in our future. And hopefully this is some food for thought when it comes to future education and future training. Also right now, how we as organizations develop those skills right now, and how we bridge that gap between what is happening now and what might happen in the future. Thank you.
Yeah, I mean, a great panel, and agreed with so many points. And I think I'd like to use my 2 minutes, was it, to say that I think we should start shifting away from that frame of tech or legal tech being a black box, because I think it doesn't serve us in the right way. And I felt Denis's very passionate objection against the inherent apprehension against technology, where we could say, yes, all software is buggy, so it must be bad. Shh, legal tech, bad. And it is weird, because at the same time, when our human colleagues make a mistake, we'll say, there is human. It's human nature. So there is I do very much feel that it is unfair. But at the same time, we need to be realistic and say, okay, well, the scalability of the problems, if my colleague screws up a particular case, then the worst he can do is screw up one particular case in the hour that he's working on that. If I have my AI assistant working on that, that could scale much quicker, and it could be working on 10 or 100 different cases at the same time. So the scalability of the problem is quite big. So I think I'd like to end my my 2 minutes with two things. So one, I think we should approach technology as an iceberg, not as a black box. So what I usually say is, we as lawyers, we're used to looking at the tip of the iceberg, but beneath that iceberg, beneath the water, is a huge mountain of technology that we need to be able to understand and bridge, and that we can only do that by asking the right questions and by ultimately talking across disciplines. So it needs to be a joint effort, as has been said by the panel before. Secondly, I think we need to approach legal tech not with apprehension and fear, but with annoying curiosity and a willingness to learn, not just within our own field, but from others adjacent as well. Thank you.
Okay. Well, yes, I think there's 2 points that I wanted to make, one in relation to education and the other in relation to the people involved in the system. I think that I used the wrong term. It is cross-disciplinary, not interdisciplinary. Apologies for that, Mireille. But yeah, I think that when I talk about education, I think we need to not only educate lawyers in how to use legal tech and understand it, but to go beyond their view of themselves as lawyers, be ready to defend their view of things, okay? Not be afraid to use terms like black box if that's what they believe is going on in the situation, but be ready to identify exactly the same limitations in human decision making, and be honest about that. So not to shy away from anything. And I also think technology, we need to collaborate to ensure that technologists are also educated in the field of law. And I think that, when we essentially, as we develop the kind of education system, prepare to ensure people can work together, prepare people to collaborate across disciplines. And that is something that really needs to be addressed. Second point, I've only got a few seconds left now, but people, it's being aware that when people are interacting with these tools and understanding whether they're working, they are helping the tools. They're not critiquing them in the sense of like saying, well, this is problematic because they've got just an anti-technology view. They're essentially core to the design, to the effective design of the tools. The effectiveness of the justice system is based on the response that the people have to it. It's not an add-on. It's not something that we do because we're being nice. It is core to the effective function. Okay, and and age, I don't know. I feel like that can be a bit of a sort of detour when we start to think, well, when the young people get older, we'll have fixed the problems. I think we need to be ready to address these right now and use the knowledge that we've got right now.
So I want to issue maybe some kind of warning for the colleagues in private law practice, which is that there's a lot to software that is akin to infrastructure, meaning that if you put your resources together and to agree and cooperate to build better software, it will be more efficient. It will like dominate all the other solutions that you could make. And I mean, there's a good reason why private legal practice is fragmented. It is because to avoid conflicts of interest when you're representing two parties that have a difference between each other. But if private law doesn't build the affordance to be able to mutually build legal technology tools that will benefit all firms and all legal cabinets, then I fear that an outside company will like make a big model or a big legal formalization for them and then sell it to everyone and then extract rent, with a loss of control, which to some extent, if I've understood correctly, is a little bit what legal publishing has managed to make, right? So maybe we want to avoid that for legal technologies in the future for private law practice.
So I'm going to comment on a few things I heard that I really found interesting. Sophia, she's gone. Okay. Yes. Anyway, I like the point about like, what are we trying to do? And I think linked to that is who will actually fund the good stuff, right? Because the companies that are in this thing at the moment, that's not their first question. Willy, I really like the thinking about a tool for developing legislation, and we obviously didn't have enough time to have it demonstrated, but I'm also curious about how that will change legislation, right? How will that change how legislation is written? Is it just a tool that makes it sort of easier and more efficient? Does it mean that legislation will, for example, have really good affordances, like involve more people collaborating in its construction, for example, because that's enabled better than, sharing Word files or something? Does it constrain in any ways? Is it easier or harder to, ensure, that it sort of makes sense and has a flow? Like I would love a demo if that is available anywhere. And then I was thinking back to the paper I did yesterday, the thought piece I did yesterday. And I found a lot that was said that sort of intersected with what I was arguing there about education. So Martijn talked about lawyers being wooed. And I actually think the best solution for that, Mireille, is your curriculum, right? It's the bringing into law schools a ability to analyze the affordances of tools. And that is exactly the sort of antidote to the wooing problem. And then Cari talked about working together cross-disciplinary. That was my sort of second option from yesterday. And on my third option, well, if we're going to have computational law engineers, maybe we can make a program for them to study that. So thank you, everyone.
Thank you again to the panel. We've now got around 20 minutes for discussions, questions from the audience. We've had such a rich discussion covering a range of issues. and I'm sure you're going to bring an extra dimension to that. So I'm just going to hand over to the audience for questions.
Yeah, so first of all, thank you so much for your thought-provoking contributions. I have two questions, and maybe for the panelists that weren't there yesterday. My name's Ola Gtiep. I'm a PhD. Thinking about how we can redesign legal protection in the context of algorithmic decision making that governments conduct. And two thoughts were especially provoked by your contributions. First of all, where do we go or where do we start if we do not only know how to instrumentalize or how to use the law as an instrument to effectuate the values, but also if we don't know what the values are? Because, I mean, we lawyers often say the rule of law is an essentially contested concept. But maybe even more so in this context, because, for example, I think almost everyone would agree with that equality is something important, for example. I mean, the extent to which can be debated, but on zich, it's something important. But if usually we have thought of discrimination in the context of you have certain suspected grounds, ethnicity, for example, in jurisprudence of the European Court of Human Rights, and algorithms technically can group people ad hoc, so they can see correlations that maybe we as humans would not spot. Then what is equality? Should we still focus on certain suspected grounds, or what is the whole rationale of anti-discrimination law then? So that's my first question. Like, how do we even begin to know what the values are? And by the way, I do recognize that maybe you don't have the answer, but maybe I'm mostly wondering, because I'm dealing with these questions in my own research as well. I'm mostly wondering, do you have any advice for how, as a researcher, we can really tackle these issues? And so the second question I had was, and I was especially the thought especially arose because of the second speaker, because I think you said something about we have to design rules so that they are implementable, right? And that sort of linked for me back to what our keynote speaker said, because, for example, if we make rules implementable, I think Pascal Citroen says that if rules are made implementable, or if rules are put in code, then sometimes, and I hope I quote her correctly, but then sometimes discretion is taken out of certain legal provisions so that they can be put into a mold of more binary programming language. But discretion is also quite an important part of the law, because we require that decision makers on an individual scale can make certain judgment calls, if you want. And also, to the extent that I also heard one of the speakers say something about principles and how they leave room for vagueness. And how would you make that implementable? And then it links me back to the keynote speaker, because is it something we can do and still retain what we call law?
Maybe I can take the second question. Maybe I try to say two things. I mean, in the beginning, I said we shouldn't have one size fits all. So, I mean, and I don't know how to typify these or how to categorize, but some rules can be much more easily implementable. And then the example that was given on this, the voting system, I mean, that is typically something where you would say, well, maybe by having IT specialists working with lawyers, coming up with something that can be more or less straight implement. Other law, just don't have to give it a start. You need maybe you need this vagueness. You need you need a little bit of phraseology that allows for interpretation. I said it's on the one hand no size fits all, but there is part of the law where I mean typically in commission speech. You have things like implementing rules, delegated decisions, where it's getting much more technical, and then then having something that is digital ready that makes much more sense. So I mean, I try to say the two things. On the first question, I don't have the answer.
I can come in on the first question, not with an answer, but maybe with 3 points. The first point is, what value should we start with? It's probably a question philosophers have been debating for a very long time, and to the best of my knowledge, they haven't reached final agreement, nor have the politicians. So we're not necessarily going to be able to draw up a list. But what we can do is certainly recognise that some values are stable. I mean, one of the things I find really actually quite annoying about the sort of framing of AI ethics is it sort of makes up special values that sort of only count if you use something called AI, however that's defined in the relevant, in the relevant published set of AI ethical principles. And I had this argument with the Australian government in the context of robo-debt, where they had robo-debt running at the same time as they launched the AI ethical principles that they still have. They're still published on the website. And their answer when I challenged them on this was, that's okay, robo-debt's not AI. Now, to me, this is sort of silliness, right? Of saying, that when you do AI, these are your values. When you do something else, I don't know, maybe you don't have to have values. But I think there has to be a kind of consistency across context to them. And the third point I'd make is one thing that is important in systems, whether they're AI systems or any systems, is one thing we have the opportunity to do that we actually don't with humans. This is an affordance of technology, if you like, is that we can be much more explicit about the values that we are embedding in systems than we can ever be about the values that we are embedding in humans. I mean, I'm trying very hard to embed values in my children with varying levels of success in different contexts, right? But I certainly couldn't publish the list of values, right, that these children come with. But we should expect that for systems, and we can do that. So that, I don't know if that answers your question. It's not the final list, but read philosophy.
So you spoke about discretion and how that affects things. I think it's a major source of dissatisfaction with the law that rules are rigid, and that's true of normal human law and of algorithmic law. And I think that the discretion is, of course, that way in which we mitigate the rigidity of the rules. So even if we can encode certain values, we're still going to be hitting up against the same problem because we cannot foresee all the instances that could occur, right? So this is essentially an issue that will reoccur because of the nature of rules, just whether they're technically coded or not. Now, what we need to work at is how we mitigate that using technology, and if we can. Okay, so that's the challenge. But I think that we have to recognize what discretion brings to the system, and I think it has some essence with what I was talking about, the kind of porous nature of justice and the way in which we respond to slight changes in perception or slight changes in values that occur, and the kind of pushback against incorrectly coded in, edicts from above, which purport to reflect what we want them to, but may do so imperfectly because we are imperfect. Okay, it's not a tech problem. It is just a problem we have to deal with.
Hello, I'm trying to hold myself because basically this is, each one of you represents a bit of my research. So I'm very looking forward to, it seems like each speaker represents an actor in this complex environment. So we have the commission, we have a lawyer, we have representatives of lawyers, we have legal education, we have a developer. So these, all of these actors have embedded cultures, and I think they interpret law differently. And I guess even at the commission level, if we just think about it, like, as you mentioned, better regulation, which I think is very much predicated on impact assessments, stakeholder discussions, and also evaluation, and the evaluation of the evaluation, and evaluation feeding the next impact assessment. So, but at the same time, the regulatory advisory board is also saying that the commission sometimes is biased regarding a certain option when doing impact assessments. So, but I guess that's part of a culture. But the same level to lawyers, we have billable hours, we have to justify our clients, certain choices we make. And then education have funding incentives. So we have to live with this. And I'm not sure if we asking too much of technology to solve these complexities. So and my question is, and I guess whoever wants to pick it up, is in such also procuring processes. And again, I see something very similar in the Commission approach. On the European Union approach, it's not just the Commission, and developers both have a problem-solving approach to how, to, let's say, law. And I guess the different, like how we understand what the problem is and what a solution is quite differently. So, so my question is, what is the future legal method? Because it seems like, of course, law is not a bag of rules, but sure, there are lots of bags with lots of rules in it that complement each other with, let's say, local biases, which is actually what allows us to understand anything. So I wonder who dares predict what can we do? Because I think we all know what we are doing without knowing what we are doing next. So please.
Maybe I can try to pick it up for the developers part. So of course we do problem solving. That's what engineers are trained for. But then the problems comes where you actually let the engineer pick the problems they want to solve. But then there's a common trope amongst engineers that people that commend engineer don't know what they want. So the engineers, I have to pick, I have to decide. If only society could decide what we should implement, it would be good. So there's also some work to be done on the hands of lawyers and people that actually order the design and conception of the computer systems to actually corner the engineers into doing what's something that's compatible with the rule of law and the future of legal method.
Hi, my question was, well, actually, it was triggered by the lady who was sitting for me on the outer right of the table. But I figured I'd just pose the question to you. So she mentioned the importance of the identification, like setting a goal and identifying a problem. And in my research, which is based on empirical qualitative research into actual practices of governments developing apps for the automation of administrating decision-making processes, what I noticed is that depending on what actor in the technology development and deployment process, so to say, I'm asking, what is the goal of the technology and what problem is it trying to solve actually, I will get a different answer. And I think that has to do with the fact that all of these actors have different roles within their organizations that they are part of. And what I find interesting as well is that to them, it's like this super obvious question that I'm asking. They're like, oh, why are you asking this very basic question? You know what it's about, right? It's very obvious to them. And in that sense, they cannot see kind of themselves that, well, it's kind of like this assumption that they have that it's not like transparent to them or so, I guess. So yeah, I was just wondering whether you could reflect on that, because obviously it's very difficult once you're
in that role to like when you're inside the jar, it's difficult to read the label, right? So it's difficult to see what you cannot see, which connects to the keynote presentation.
This kind of reminds me of this this comic that I once saw, and it's quite. I'm sure most of you have seen it. If you're in IT law, then you've definitely seen it, and it's the picture of what a client wants, what a quality assurance guy wants, what the developer is building, and what is the end result, and what the client really wanted. And I'm sure I can send you the link later. But it's a comic that basically speaks to even if you have a problem or a project where so many stakeholders should be aligned, everybody's still operating from their own separate silos. And I think the main problem there, because I do a lot of IT litigation as well, and the biggest reason that I see IT projects fail is because people don't talk to each other. We have lawyers operating in a silo. We have developers operating in a silo. We have product owners or managers thinking just about spreadsheets. So we have a lot of stakeholders in that situation where they should be talking to each other, but they're not. And there's actually the Standish Group publishes a report I think it's every 5 years, called the Chaos Report. And the Chaos Report, interestingly, has been reporting that agile projects, so IT projects following an agile methodology, are significantly more successful than traditional waterfall projects where people would just operate in their silos and then pass it on to one another, and then at the end say, oh, listen, are we still aligned? And they would go, yeah, probably not. So I think there's a lot to be learned in general from that report there as well. And I think that's also sort of the consensus on this panel, is that if we talk more to each other, we might be able to identify these misalignments earlier in the project and hopefully prevent them.
I might just add to that. Sorry, did you?
Yeah, I mean, I agree. I mean, agility. I mean, how you develop systems. I mean, bringing the business owners together with the business providers together, and work out the solution together. I mean, that helps quite a lot. Agile development doesn't work for sending rockets to the moon. I mean, that's different. So it also has its own subject of development, but agility does help a lot in setting common goals and trying to solve a real problem.
I think I was just going to really echo what's already been said about, obviously, working between disciplines, but I think also often it's not clear what the objective is. I think even within the client group, right? So, you might have a perspective of, say it was something for decision-making in justice, for example, there might be an objective of, throughput of number of cases dealt with or, answers. There might be other objectives that are working together. And actually, we've never had to articulate them so clearly previously. Okay, so we've been able to operate on assumptions and a kind of shared assumption of values, and then the humans interpret them as we go along. When we actually have to put those into code, or we have to, sort of have someone from outside the discipline saying, so what do you want to achieve? We might find that even of a group of people of the same discipline, they may come up with multiple answers because it's literally never had to be. I mean, there's so many definitions of justice, for example, so I'll leave it at that.
The elephant in the room when you're talking about agile in government is that you have a parliamentary process that passes law. There is a sort of working assumption that the system that you deliver is somehow independently deliverable from the law that does it, and it isn't. I mean, we know from writing software that the communication structure of the team that produce software determines the technical architecture. So you can read, for instance, the Social Security Bill Scotland 2017, which has in Schedule C a series of delegated powers for different social security benefits. If we went to Social Security in Dundee, I could take the law, I could go into the code base and show you it inside GitHub, right? So one of the issues we got with Agile is where and when do we make some of these decisions? How do we iterate? And there's a constitutional problem there, because the current trend, certainly in the UK, is to put in place a primary bill and then give secondary powers to the minister. And you're kind of going, well, and when we do co-design, for instance, we say, okay, the standard process is the minister consults, that's fine. They put a bill to the parliament then, so it's proposed, the parliament then consults and then disposes, passes the law. And then in co-design, the government goes off and talks to the users. And it's kind of like, what's the bloody parliament doing? Who has the final say? Hold on. And so one of the problems that we've got is that this sort of tech bro approach is to say, we're going to make government delivery of law agile by eliminating parliament. Well, that's not going to end well, is it? So, I mean, one of the issues I'm looking at in my project is what does iterative look like? And when you look at patterns of law, the Social Security Bill went in 2017. There was a second Social Security Bill in 2020. The plan is to do multiple primary acts, but all of this is kind of inchoate and made up, whereas in fact, we need to look at the actual implementation of a computer system will involve 1, 2, or possibly 3 primary bills, maybe 7 or 8 secondary legislative orders, and then a mass of other regulation and stuff. And all of that is kind of in soup. And how do we actually turn that into an actually agile process that has the right iteration and the appropriate things on instruments, right? So do you put paper prototypes in the bill pack and kind of stuff like that?
So I can say a few things from my experience, which is that the distinction between what goes into the law and what goes into regulation, ministerial regulations, can vary hugely between domains. For instance, if you look at tax law, everything is in the law, nothing is in regulations. And if you look at social security law, nothing is in the law, everything is in regulations, which also means that the ministry has the power to basically diminish the number of social benefits by 99% from one day to another, and the law can say nothing about it. So I would guess that the answer to your question really varies of what is the power structure in the domain that you're legislating into, and how do you translate that into the separation of power. And I agree with your point that the agile tech bro approach to saying that we should eliminate parliament is not a way to go forward, but there should be a way to fit an organizational process to deliver IT solutions in the end that respects the institutional power relations in the democratic approach to rulemaking.
In the UK, the relationship between tax and Social Security is even more constitutional. Secondary legislation for Social Security in both UK and Scotland goes to a Social Security Commission, which is a statutory body under the Parliament, which performs a sort of supervisory task. So Social Security has its own constitutional flow, whereas traditionally tax has been connected with the Treasury. And actually you have these 2 mechanisms which are kind of identical, have totally historical constitutional channels to making law. And the reason is no one's actually sat down and thought from first principles what it should be.
We'll take one last question if there is one. I think there was.
Yeah, I hear it's almost time, and maybe some food for thought also for maybe a drink. But I've been intrigued by this idea that to err is human, and I also heard Sophia say that that is actually exactly what society needs. To err is human, and I think this is one of the points in a, how shall I say, thought-provoking research paper by Orly Lobel recently, where she argues that that is one of the reasons why there should be a right to human out of the loop decision making. And I think she backs that up by some research that's being done about bias, because humans have bias in decision making, but machines also have bias in their decision making, and to combine them, apparently, I mean, I'm no expert in this field, but to combine them is also combining the worst of both worlds. So bias gets amplified. But then I think it's interesting to think about what if this is the case, and at the same time in the AI Act, but also in In the US, there are similar things happening right now. Human in the loop is being used as actually a safeguard for, yes, we have a machine, but it can only assist. It's only a safeguard, so there's a mechanism where in the end, the final decision maker is still a human. But if it is the case that it is the worst of both worlds and it actually amplifies bias, I guess I'm just wondering what that would mean for the future of actually like decision making with legal technologies.
Yeah, I mean, I agree. I mean, I guess that sort of speaks to my 2-minute presentation of just now as well. That we need to be approaching this from a curiosity perspective, not so much from a fear perspective. And that human oversight has been seen as the silver bullet. But it feels unfair because at a certain level, applications that run the right instructions can likely reproduce those same instructions more faithfully in many more times. The problem is, of course, how do we get the right instructions into those applications in the first place? And I think how do we regulate governance? Because that's, I think, what we're really talking about, is who do we trust, right? Who do we trust? So do we trust humans more or do we trust systems more? And I don't know if there's a right or a wrong answer, but I think instinctively most of us in the room feel like I can trust a human more. But I don't think that's necessarily an unbiased answer.
I'm going to say it's even worse than what you said, because law also comes in and can sometimes make things worse in that mix of human and machine in the context of bias, right? So the way that discrimination law is written at the moment, which is only works for the human version of the problem. Once you bring in a system, it can actually incentivize the programming of that system in terms of data variable inputs and what kinds of testing you do in ways that actually discourage testing, right? That you would actually want to have if a system is actually going to make fair decisions, right? You actually have people start to say, oh, we can solve the problem by removing the variable, like, you know, that kind of thing. And in fact, that can be encouraged by some of the wording in some jurisdictions, discrimination law. So law, if you like, is almost getting in the way. So the solution, though, I still think can be law. Right? In other words, we can actually go back to things like discrimination law and we can say, okay, if now we are dealing with human out of the loop or human in the loop or all of these different kinds of decisions, what should whoever is making the decision and whatever tools they're using have to do in terms of non-discrimination? And that will be different to the wording there now. But hopefully it means that whichever path is taken, pure human, you know, et cetera, we have law kind of pushing towards more fairness.
I just wanted to add one more thing, was just that, also you can't necessarily, just because you've got a human in the situation, say that they're actually going to operate and review that question. So having a human in a loop can give a veneer of, okay, there's somebody watching this, looking after it, but actually sometimes it can be harder to go against the decision than actually follow it. So that's another chaos thrown into the yeah.
Well, I hope you will join me in sending a love letter back to our fantastic panelists, and particularly to our keynote.
Yes. So it's 5 o'clock. So anybody who needs to take the Eurostar or any other train, is welcome, of course, to leave. I'm just going to wrap up. And I think I'm going to wrap up the amphibian conference. So here we are between fish, reptiles, and mammals, right? And this reminds me of another great insight that was shared today. When you're inside the jar, you can't read the label. However, if you have fish, reptiles, and mammals, maybe you can, because you can, you know. So I understand that the idea is that we're emerging once again from the sea onto land. After all these jokes, I did try to think of what was yesterday and today about, so the future of computational law and the future of legal method. I think it's very important to say, to emphasize that this conference and the journal take a normative approach. So the talk about neutral this and neutral that, whoever talks about neutral is hiding assumptions, and that's very productive. You don't always have to go back to assumptions, but in this kind of conference, it's better to put them on the table, because then you can have a look at them, so get out of the jar. So the normative approach here is, for instance, that there is no liberty without reasonable equality, the point of Amartya Sen. If we don't have reasonable equality, then those who have less equality are not free. And of course, there is neither liberty nor equality without institutionalized countervailing powers. And I think this conference brought forward not only Montesquieu, who some people might think in the context of law is rather a cliche. I don't think so, but it might be. But they also heard a lot of Karl Polanyi swing around about counter movements he spoke about. Which raises the question, do we need economists here? Where are the economists? Okay, so then we get into the Schmidt, where is Adam Smith here? So which Adam Smith? The Adam Smith of the theory of moral sentiments, or other Adam Smith who, as we all know, the Mont Pelerin Society, one of the key figures of the Mont Pelerin Society, it's a rhetorical trick to say, as we all know, because now you're all going to say, oh shit, everybody knows it, but not me. But I advise you to look up Mont Pelerin Society. One of the members, I don't remember which member, took Smith's famous work, The Wealth of Nations, and abridged it, took out anything that might refer to equality or morality, abridged it, and said, this is Smith for normal people. And so, do we need economists? Well, that depends. Good. The project is based on 3 concepts that aim to inform the projects, and those concepts are the mode of existence, of course, the mode of existence of law. And that means that, yes, the project thinks that text-driven law, as it has been, will of course not survive. It will change. And if it doesn't change, then it will disappear. So that's key to the whole project. We're moving not just from text-driven to computational, but from a new type of text-driven to the integration of certain specific computational tools. And that's why we need to talk about legal method. And I'm extremely impressed with the very rich output of today's roundtable. So legal search plus, so the computational legal search. Just the term legal search is of course completely new. I didn't have a subject, legal search. What we did was case law analysis. Sophia Adams-Bhatti talked about legal search, using it, developing it in a way that enhances critical thinking. Which would mean moving from close reading, which is how lawyers are trained, case law analysis, close reading, to distant reading, using an intermediary in the form of software to read an amount of text that you would otherwise never be able to read. Why? In order to, again, close read. And a lot gets lost and a lot gets gained, and we have to think how. Drafting legislation as part of policy making, as part of a policy making ecosystem. Willy van Puymbroek spoke about that in terms of augmentation, for instance, of developing digital readable law. The LEOS project, one of the legal technologies that we have extensively investigated in our typology. emphasizing that this is, of course, both about efficiency and quality. And then using the term, very interesting, from editing to drafting. So not just editing the law. For instance, I'm thinking of a common-otoso, but also drafting the law, which is another thing. Access to justice, so adroits, informing policymaking regarding legal practice, and then paying key attention to real-world interaction and impact. So listening to people, talking to people, but also about what you later said, where is the competence, or how is the competence to give legal advice defined? It's defined in different jurisdictions in a different way. There are now jurisdictions that allow people who are lawyers, maybe not even, but who are not inscribed in the bar to provide legal advice or a specific type of legal advice, and others are not. So this is all in movement, and I think it is important. There is the issue of legal practice itself, and let's take big law. So that's to a large extent business to business, shifting away from the billable hour, Martijn, Loth, protection against tech vendors, training lawyers on how to use legal text, from training your junior associate to training your digital legal assistant, including the kill switch. Quality management and risk management, which we like to outsource, but how to implement it, how to connect with auditors for tax. What about the insurance for liability of deploying these systems, of outsourcing stuff to these systems? A need for regulation, for standards, for guidance more generally, and of course, learning to ask the right questions. Develop an annoying curiosity. I love that. I sometimes speak of constructive distrust, which I think any lawyer, if you don't know how to develop that, you're probably not a lawyer, but something else. Rethinking legal education on adroits, to develop new skill sets, to engage in a constant permanent learning, not because that's some sort of maxim that somebody someday invented, but because we are not going to survive without that. Rethinking professional education, Lyria, Bennett, Moses, how to help courts to invest in what legal technologies, how to raise what sort of questions. Think of our typology of legal technologies, where the first question should be question 0. That's the question we, of course, prefer to, well, let's not say we, but the question that is easiest to circumvent. We don't have time for that now. Leave it to the philosophers. Question 0. Let's just go ahead. Issues of competence, of context, and always the important issue of how. Legitimacy, the quality of treatment of citizens, of legal subjects, of natural persons, because in the end, that's what we care about, I hope. Human beings, amphibians, etc. Cari, Hyde-Vaamonde. So about the quality of treatment, the lie detection, the notion, you didn't mention it, but that's what you were talking about ground truthing and how this is gamed and played around with, where the question is, do the people who put this forward actually know that they're deliberately playing a game and lying about ground truth? How can we find a lie detector for that? That would be great. The need for participation with real world publics, so collectives, publics. John Dewey's understanding of democracy, when he thought democracy is not finding a representation, voting once in 4 years, and then we have democracy. No, it's having a representation that is going to take care of politics, yes. Plus, the minute you sense that they are not taking good care of the interests at stake, form publics, and get down to work. So those affected by these technologies should be able to get together and enforce, make their voice heard and enforce being listened to and taken into account. Then, of course, the issue of disciplinarity, I've now completely let go of inter, trans, multi, and cross, and just talking about disciplinarity now and domain-specific expertise. That's about a practice of law and a practice of technologies, engineers. Denis Merigoux, critical software engineering skills and expertise for legal practice as critical infrastructure. And I completely agree with Martijn Loth. It's not understandable how Annex 3 of the AI Act can say that it's all about the judiciary. Of course it's not. Anyway, so do we need a subdomain, a sub-expertise, a professional domain of computational law engineers? Do we need some sort of professional body with a ethos, a deontological code that can be enforced, with an arbitration court that has the capacity to issue verdicts that have legal effect? So I'm not even talking about certification, but a real process that is public, like for doctors and for lawyers. So lawyers, policymakers, politicians, I heard, should corner the engineers into developing the right systems. Wow, what a fantastic way to say it, which doesn't mean we now know how to do that. So there is this term, mode of existence of the law. The mode of existence of the law is definitely going to change. It has been changing for the past 500 years. And since we're switching technology or integrating new technologies, let's put it this way. Before there was writing and the printing press, all law was oral. There are societies, they've been studied extensively, that had oral law. Of course, that was not law, because it was a very different animal from how we understand law. But it was a normativity that kept things reasonably in place. Then came handwritten manuscripts, then came the printing press. When the printing press began to proliferate, and you got written law, enactments, legislation, then we began to speak about unwritten law. Now, before we had written law, we had no unwritten law. We had oral law, but that's not unwritten law. Unwritten law only exists if you have written law. Some people would say that's French philosophy. No, it's not. Or maybe it is. Maybe the French get this point and other jurisdictions have more problems with that. But it's key. Yeah? So once we get computational law, we will get non-computational law. And that will be something different from the current text-driven law. And we don't know yet how. And it's also very much up to us to develop that. So the big question is, what do these new technologies, data-driven, code-driven, hybrid, what do they afford? And so I'm not a technological determinist, so I don't think that a text-driven infrastructure necessarily brings about the fantastic rule of law. No, it happened, but it could have been something else, and we have very bad rule of law institutions, yes. But what are the affordances? They're certainly changing because the technology matters. It induces certain behavior. Sometimes it enforces certain behavior, and it discourages certain behavior, or it precludes certain behavior. So we have to take a good look at that. And then, of course, the final thing is how to think, how to develop legal protection by design. So by just writing a text and enacting it, we cannot save the rule of law. We will have to embed the norms and values that we want into the infrastructure. We're not talking about a technology or an application. We're talking about an infrastructure. So at that level, we need to think how to develop that infrastructure in a way that that re-engineers legal protection. Well, that is what we have been trying to achieve or to think about in the past 5 years. Those 5 years are running out. I'm absolutely delighted to see all these new thoughts. When I wrote the project, of course, I was hoping that people would take these concepts and the other ideas and go running with them, because that's what these projects are about. And I've seen that, of course, during the past 5 years in the team, in the conferences and the seminars. But this is a fantastic public way of showing all the questions that have to be raised. As we know, science is not about giving answers, but about developing the right questions. And I think we certainly did our best for that. Thank you very much. And I hope you still have some space between your two hands, because I also want to thank very much Pauline McBride and Lawrence Diver for organizing this great roundtable.